petition is over.
My
Actually,
lord,
the writ petition
no,
will be over now.
Writ petition is pending. That petition has come. May I pray your lordship, instead of this writ appeal, your lordship may target the writ petition because the pleadings are completed.
All right. This writ appeal is directed against an interim order. What is the delay, sir, here? You see the delay.
Pardon, my lord. This matter, my lord, on behalf of Mr. Das, my lord. As a writ petition, I got the benefit, my lord.
No, that benefit, my lord is saying, by virtue of the interim order, and we have given that benefit subject to outcome of the court
So
case.
it's implemented anyway. So delay is condoned. This writ appeal is directed against an interim order passed by the learned single judge, granting some interim relief to the respondent. Counsel of the appellant states that relief has been granted subject to the outcome of the writ petition. In any event, if the writ petition is still pending, a direction is issued that it be disposed of as expeditiously as possible, and preferably within a period of 4 months from the courts not inclined to interfere with the impugned interim order. The writ appeal is disposed of.
Supplementary list item number 5.
My lord, item number 5 to item 11. All are those matters on the ground of delay and latches more than
delay
5
latches. 5 to 11.
That corresponding writ appeal number is 535 of 2013. On Monday, your lordship.
Correct. Similar address, 530. All right.
Supplementary list item number 12.
None appears to.
Supplementary list item number 13.
None appears. This was from opposition.
Supplementary list item number 14.
None appears.
Supplementary list item number 15.
May I please, your lordship? In item 15, my lordship, in the first appeal, I am for the respondent number 5, and in the second appeal, I am for the appellant, your lordship. In both.
First, you say none appears for the appellant, dismissal non. Second one?
Yes, your lordship. In the second writ appeal, my lordship, I am challenging the order dated 13/1/2014 under Annexure 7, your lordship. Now, what has happened, your lordship? Pursuant to an advertisement in 2011, I was selected as a Sikhya Sahayak. Now, the petitioner in the present case, he has challenged my appointment on the ground that I have been selected in the post of Sikhya Sahayak, which was reserved for the physical handicap candidates. Now, my lordship, what was the finding of the learned single judge? Master, kindly see page number 52. That is the impugned judgment. Now, my lordship, kindly straight away come to page number 60. The internal page 7 of the judgment.
Yes.
At paragraph 12, the honorable single judge, he has quoted the vacancy position of the advertisement. I'll just read it out, your lordship. Category of post, BA B.Ed. For ST male, 2 posts. ST female, 1 post. SC male, 1 post. SC female, 1 post. OBC male, 1 post. SCBC female, 1 post. I am concerned with the SCBC female. The entire case of the petitioner before the honorable single judge was, I was appointed against the physical handicap post, which was reserved for the physical handicap. But my entire case is, my lordship, I was appointed against the SCBC women post, your lordship. The 1 post was reserved. Now, my lordship, kindly see at page number 61, paragraph 15. Very short, your lordship, I will not take much time. Paragraph 15. It is apparent from the records that only 1 female of general category has been engaged, and the second post has been filled by SCBC women category. And accordingly, OP number 5 has been engaged in SCBC women category. That means I was the operating by number 5, your lordship, before the honorable single judge. In BA B.Ed stream, thus the appointment of OP number 5 was in violation of the terms and conditions of the advertisement. Now, actually, what my submission is, your lordship, the first SCBC woman who was appointed as a post of unreserved woman, she was given that appointment on the basis of her merit. Now, it is a settled principle of law that once a candidate has, yes, Your Lordship.
Common merit, then it is counted in the general category.
Yes, Your Lordship. Now, the Honorable single judge dealt that because there was only one post of SCBC woman and another post of unreserved women was filled up by the SCBC female category, my appointment is illegal. That is the only case. Now, my Lordship, with regard to the case of the appellant, in the first case, my Lordship, kindly page 62, paragraph 19.
Yes.
However, it is seen that after lifting of the stay order of the physically handicapped commissioner, the authorities have issued engagement order in favor of the petitioner, but he has not joined in pursuance thereof. Therefore, he has forfeited his right to claim engagement as Siksha Sahayak in the physically handicapped category. Now, the ultimate conclusion at paragraph 20. In the result, on the basis of the aforesaid discussions, this court comes to the conclusion that
So he is not granted relief, but your
appointment was cost.
Achha. What do you say, sir? How is this sustainable?
Lordship, permit me, then first case is mine. I can convince your Lordship because first case is mine, Lordship. Lordship, kindly, from the day one, Lordship, kindly look at my prayer, Lordship, of my writ application. Lordship, kindly, the advertisement I invited. That is it, annexure 2, Lordship, the advertisement. Lordship, kindly see the advertisement. Running first 25 of my brief, Lordship. Just I'm reading first graph, just last two sentences, Lordship. The eligible candidates, Lordship. The eligible candidates should submit their applications in plain paper in the following prescribed performa before the office of the collector and registered post or by hand before 13/9/2021, Lordship. That is the cut-off date. The defective application will not be taken into consideration. The application will be addressed to the collector. Pursuant to this application, I applied for the physically handicapped quota, Lordship, and the respondent of 5 filed on the category of ACBC, Lordship. But Lordship, subsequently, after the cut-off date, in obtaining a physical handicap certificate, he applied under the PS quota, Lordship, which is accepted by the authorities. That is the crux of the matter, Lordship. Then the cause of action arose to approach this honorable court, in my grievance, a application after cut-off has been accepted by changing its category, Lordship. That is the crux of the matter. Then, Lordship, kindly see, just I want to bring Lordship's kind attention, only 2 to 3 documents which I have annexed, Lordship, in my writ application. Lordship, annexure 5, Lordship, kindly see. Page 30. Annexure 3 is your appointment order. And Annexure 5, Lordship, page 30, this is the draft selection list, Lordship. Lordship, kindly see serial number 9. Her name finds place as Rajeshri Behera. Lordship, kindly see the below they have given the SCBC. And Lordship, kindly see that they have given an indication of HI 45%. Then, Lordship, kindly see Annexure 8, running page 35. Hearing impairment, HI, Lordship. Annexure 8, which has been obtained on 9/11/2011 after the cut-off date by the respondent of 5. And Lordship, kindly see that they have given this is the disabled certificate. And Lordship, the reasoning. Speech and hearing disabled and has 45%. Lordship, then Lordship, kindly see the next Annexure 9. Again, her name finds place at serial number 9. And Lordship, kindly see they have indication of HI 45%. Then Lordship, another 2 documents have to brought to Lordship kind attention.
Can I?
Please let me complete.
At least kindly.
Let me complete.
The last.
Let me complete, then you will argue. You are so hurry. Lordship, kindly page 73 for a moment. 73, Lordship. This is the list prepared by the opposite parties, the state government, Lordship. And Lordship, kindly the serial number 1, page 73, Lordship. List of the physical handicapped, Lordship, persons, Lordship. Lordship, kindly see Rajeshri Behera, serial number 1. When the respondent of 5 Millard has been placed at serial number 1 of the physical handicapped quota lordship. Then lordship, another time I want to draw lordship kind attention. Lordship, that is at the order of this honorable court. It starts from running page 130, Annex 17. Lordship, 134 last line I'm reading, Lordship. This is observation of this honorable court, Lordship. 134. As against one vacancy reserved or physically handicapped, Rajashree Behera, serial 9, respondent 5, has been given appointment. Military is clarified with this honorable court. She happened to be a SCBC candidate. No other candidate in the category of physically handicapped more meritorious than Rajashree Behera finds place in select list ST candidate, namely Kishore Kumar Khatwa, suffering from disability features in the voting list. Therefore, Rajashree Behera has been selected and given appointment against the vacancies reserved for physically handicapped and not against the vacancy meant for SCBC candidate, right? So this is objection of this honorable court. In the first instance, they have admitted this person has been given appointment under this physical handicapped quota lordship, and I was entitled to get that appointment. I have been prevented. She has been given appointment under the physical handicapped quota lordship, and subsequently, while filing counter, they just reversed their stand lordship. Now they are saying the person has been appointed under SCBC. Then lordship kindly to come to honorable on single just finding lordship. The rigid finding also their lordship, because he cannot consider it as SCBD candidate lordship. Just lordship, I am reading the judgment of honorable single judge. Just I want to read lordship from serial number para 790. As per the list prepared and published in the website on 25/11/21/11 for production of original certificate on 30/11/22/12, opposite partner 5 remained at serial number 26 and opposite partner 6 remained at serial number 20. The draft selection list was signed on 12/12/2011 and published on 15/12/2011. It is further stated that as the stay order passed by Physical Handicapped Commissioner, the post outage for physical handicapped was kept vacant, and the trained graduates were only selected according to their merit on percentage of marks. Accordingly, opposite partner 5, who was at serial number 8, the TG arts under SCBC and opposite partner number 6 and serial number 3 under physical handicapped category were selected. According to the engagement order of opposite number 5 was issued, but due to the order of the stay of commissioner of a disabled person, the engagement order could not be issued to the petitioner. However, it is stated that after vacation of stay, steps were taken for issuance of engagement order. According to the engagement order was sent through rest of the post. The opposite partner of 5 was allowed for verification of the original certificate on 22/12/2011 for issue of engagement order in her favor. The selection for TG arts only for verification, but physically handicapped categories were not called for. The opposite part 2 and 3 denied that application was submitted on 22/11. At the time of verification of the original certificate on 22/12/11, the candidates were asked to submit one set of copy there. All certificates duly attested on the same date. The petitioner in his RTA application asked for supply the certificate without mentioning the date, and a copy of the certificate received on 22/11 was supplied to him. Regarding opposite point 6, it is stated that the authorized authenticated employment residence certificate submitted at the time of application from along with all academic certificates from which his qualification was known as +3 arts. Hence, there was no deviation on his case. Opposite partner 2 and 3 submitted that only because of the stay order passed by the Physical Handicapped Commissioner, one post on the category was kept vacant and no illegal selection was made in respect of opposite part number 5 and 6. Hence, it is stated the rate petition is devoid merits and set to be dismissed. Opposite number 5 is important. Opposite partner 5 has her counter affidavit. It is admitted that she has been made application for the post of Shiksha Sahayak under BA BD category. It is also admitted that the petitioner was an applicant meant for physical handicap post. Please open up 5. Her main contention is that petitioner has tried to mislead the court. Opposite 5 is a candidate having qualification of BA BD arts and has got the engagement order for the post of SCBC women category. Opposite partner 5 asserts that she has not got engagement order for the post meant for the physically handicapped person and she was not an applicant for the post. Besides that, the petitioner is an applicant meant for the physically handicapped post, and the post has not been filled up by the authorities, and still it is lying vacant under Annex 9 of the writ petition. Therefore, the statement of the petitioner that the physical handicapped post has been awarded to the opposition of 5 is false and justified. Hence, the parade for then the court considered these following points, Lordship. And so far, Lordship, then Miller, Lordship, kindly listen. Next 22, there is an effective hearing, and the honorable single considered all those points, Lordship. In order to effectively adjudicate the issues, it is necessary to look at the advertisement issued by the collector, Jharsuguda Annexure 1. This annex is not disputed by any of the parties. At page 14 of the advertisement, the table of the different number of posts reserved for different categories has been given. The relevant portion is produced, Lordship. The total number is 13.
No need to go. He read the whole thing, sir.
But Lordship,
he just now read this entire table, column by column, he read it.
So
don't repeat it now. Yes.
Then my humble submission before Lordship, the honorable single said there is no post of SCBC. The SCBC post already been filled up. So there is no chance.
That's where the mistake is, sir.
Lordship,
SCBC candidate
Lordship,
scored high in the general merit itself.
Lordship.
So that has to be, that candidate will not be considered against the SCBC quota. That candidate will be considered against the general quota.
Maybe, Lordship. But Lordship,
which means the SCBC post is not filled up. This appellant, she can easily fill up that post.
I don't mind, Lordship. That is not my case. My case, a humble submission.
So if you don't mind, then her appeal has to be allowed. That's the end of the matter.
I am concerned on my appeal, Lordship. I am not standing on his appeal, Lordship.
That's the whole problem. See, the way the whole impugned order is,
Lordship,
she has been denied relief. You have also not got any relief. So either of you is not happy.
No, Lordship, my humble, I am not against her, Lordship. I am on my own case. I am.
But your problem is in the last paragraph. Because you do not join.
No, Lordship, that is not the correct fact. Lordship, I have given in my answer in my rejoinder.
What?
Lordship, because Lordship can from the day one and before, Lordship. And at any point of time, it has been directed by this honorable court to take the position, Lordship. Rather, in the meantime, when a Lordship called for the entire records, they issued this appointment order. And Lordship take condition to withdraw the writ application. But I denied because I have under your Lordship's disposal, and I was seeking a direction from your Lordship. Because
what is your problem? If they're giving you a post, what is your problem in taking it up?
During pending the writ application.
So the relief is being granted to you.
That's true. But because I had approached before Lordship, was it
you could have easily filed an application withdrawing the writ petition.
Lordship,
I find this strange. When they're offering you a post, why would you not take it?
Because Lordship, I have immediately approached Lordship bringing.
If they're granting you relief, what is your problem, sir?
Lordship, immediately I had approached and by a rejoinder saying that this is the condition, Lordship.
I don't know. I find it very strange. You should have simply joined the post.
Well, that's true, Lordship. But because when I before Lordship,
and after 10 years, when was the passed?
Lordship, that is
because of your advice to your client, whatever that advice was, you've kept him out of job for how many years now?
I have worked for more than 11 years, Your Lordship.
No, 14. Yes. This is a 2014 order.
Yes,
we are in end of 22. Because of, I don't know what advice you gave, your client has not joined. He has not joined till now.
That appointment order, from the day one, I'm ready to join, Lordship. Because
what is that ready to join? You simply join. What is that ready to join?
Lordship, client.
If you're not interested, you say you're not interested.
Lordship, what they have done, Lordship, can you see? I was entitled to get Miller order of appointment since the date of advertisement, Lordship, since the date of engagement. But in the mid-session, Miller, they issued the certificate only when a Lordship called for the records. When the Miller,
you want the job, you don't want the job.
I want the job, Lordship.
Why did you not join?
That's why, Lordship, I am fighting for this.
Then why did you not join? Single said you're not interested, you're not joining.
Lordship, kindly see their statements. Till that post is lying vacant. Only I'm seeking a direction from your Lordship.
I don't understand. When they're themselves offering you the post, why do you need a direction?
That was it. That was in a subsequent date, Lordship. That was I was losing my.
So what is your problem, sir? Then you modify your prayer saying that I should be deemed to have been appointed from an earlier date.
That's true, Lordship. But
instead you have not even joined the post.
That's why, Lordship, I'm continuously I'm before Lordship.
I don't know.
That's I understand. Lordship,
I don't understand this at all. Sorry.
That's true.
Yes.
But Lordship, kindly consider one aspect.
Yes.
Lordship, kindly consider one aspect. From the day one, I'm challenging the data advertisement. I have approached your Lordship. And when lordship when lordship is session over the matter and your lordship call for
I
the
find this very strange, sir.
but lordship
Absolutely
when the
strange.
to withdraw the writ application.
Obviously, he's not interested in the
No,
post.
lordship, I am
Yes,
I'm
yes.
from the day one interested. Can you
Yes,
see
yes.
this aspect, lordship?
Yes.
I am from the day one interested. That's why I'm little lordship before lordship since 2011. Otherwise, lordship kindly see my prayer, lordship. What was my prayer, lordship? That prayer was very important, lordship. That's why I could not join, and I brought all the facts before lordship. My prayer was, lordship, to give my appointments is 23/12/2011 because
First you join, first you start working, then you say from which your appointment should
lordship,
relate.
correct. That
Here you're not, you're saying everything should be on your terms. Right in the
Because-
beginning, they should tell you you're appointed from the date of the advertisement, only then you will join.
That's true.
You're
but
putting all these
because I'm a
conditions.
law-abiding citizen.
Naturally, what law abiding?
Lordship, I am a
You're
lordship.
dictating things. Basically, you're dictating.
No, lordship.
Yes, yes.
Because I was before lordship. Your lordship.
This is not an argument at all, sir. It is not impressing us.
It is a prayer, not
It is
argument,
not
lordship.
impressing us. So don't keep on repeating it.
But my
You have
prayer,
no explanation why, when they offered you the post, you did not take up the post.
but my prayer would be, lordship. My prayer would be, lordship. Kindly still that the post is lying vacant, and I am before lordship. Lordship, kindly give me some direction. I can join, lordship.
No need for any direction, sir. You're completely mistaken on this.
But
No,
lordship-
the court prevented you from joining. They gave you an offer. You did not join.
But
That's
this
all.
finding up.
There was no stay order saying if they offer you the post, you shall not join. Is there an order by the court saying you shall not join if they offer you the post? Is there an order by the court?
No, prior to
Then
that, I have, lordship,
What is this? What is this
lordship, this
argument?
occasion arose only after lordship's intervention. Lordship,
Sir,
because there
did
was
the
no
court-
because
Did the court prevent you from taking up the post?
no, lordship. I was seeking,
Then why did you not join?
only I was seeking a direction from this honorable court.
Why do you need a direction, sir?
Because I was before lordship.
Unless
I
we
was
are-
under disposal of a lordship. Because
Anyway, if this is your understanding, you're thoroughly mistaken. You can go on repeating it 10 times, but you're completely mistaken, sir. As if the court somehow prevented you and the court's direction, somehow you could not join. All this is your own imagination. Yes, what do you say?
Yes, Lordship, turn to page 91
Yes,
for the first read of it.
yes.
This is the advertisement, my lord. Your Lordship may see BABD. There, my lord, the position is like this: ST 3 posts, SC 2 posts, SCBC 2 posts, and general.
Sir,
5.
that candidate, if she has scored high on the merit,
I am coming to that.
that's the
Correct.
only point, sir. Nothing
Yes,
else. Is,
correct. She will not come to that fold, my lord. Your Lordship may turn to page 30. That is the merit list.
yes. Padmasini Khamari, she is the SCBC.
My lord, your Lordship may see her position is at serial number 9.
No, that is the appellants.
Yes, my lord.
No, we are on that other candidate.
Your Lordship may see that from serial number 1 to 8, there are 2 SCBC women candidates.
Correct.
One SCBC will be treated as you on the basis of her merit.
Correct.
Second SCBC will be treated as SCBC.
No,
Not
she is the second one, sir.
She is the third person.
No.
Your Lordship may
There is
see
only one woman
Pad-
at serial number 6.
then serial number 3 also.
No, 3 is not a woman, sir.
It's a male.
It's a male. You're completely mistaken.
Sorry. Serial number 6, Padmasri Khamari, will not come under UR category.
Why?
Because 5 posts are there for UR.
Yes.
No, only
Yes.
2, sir.
No, my lord. Your Lordship may say advertisement.
Sir, SCBC woman, there is only,
SCBC women, 1 post.
no, in the UR women, how much there is?
1 post.
2.
2 posts. Yes, my lord.
So
Yeah.
why can't she fill up the second UR post for women?
Padmas. Yes, my lord.
Ah,
Then she will come.
correct. That's the end of the matter, sir.
Yes.
You see,
So far, other party is concerned, we have issued appointment order. He joined. He did not join.
all right. You see, both these appeals are directed against the common, are directed against the same judgment dated 13 January 2014, passed by the learned single judge, disposing of writ petition civil 6422 of 2012, filed by Binod Bihari Bagh, the appellant in WA 47 of 2014. Full stop. While directing notice to issue in the first mentioned appeal on 26th February 2014, this court directed status quo to be maintained. As regards the appointment of the appellant in WA 41 of 2014, that is Rajeshri Behera. Stop. On 14th of 2014 paragraph, you say the background facts are that an advertisement is issued for the post of Sikhe Sahayak in the BA B.Ed category by the collector Jharsuguda on 14th September 2011. Sorry. As far as the appellant in writ appeal 41 of 2014, that is the writ petitioner is concerned.
Sorry, Lordship, may I take leave, Lordship? May I take leave, Lordship?
All right. He was a member of the, he belonged to the, he applied for the post of trained graduate arts, bracket Sikhe Sahayak, meant for physically handicapped, bracket TH. Full stop. His prayer in the writ petition was that the final merit list should be quashed and the selection letter issued in favor of Rajeshri Behera, bracket, who was impleaded as opposite party number 5 in WP Civil 6422 of 2012, bracket, should be quashed. As Sikhe Sahayak, bracket SS, should be quashed. And instead, he should be engaged in her place. Paragraph. Pursuant to the pleadings in the writ petition, the learned single judge first noticed that as part of the advertisement, the reservation made in different categories was set out. Full stop. What is relevant as far as our case is concerned is that in the general category, 2 vacancies were reserved for female and 3 for male. And in the SCBC category, female, 1 vacancy was earmarked. Full stop. The vacancy in the PH category. Paragraph. In the general merit list that was published, Rajeshri Behera figured at serial number 9. Whereas
Padmasini Khamari.
no. What about this Binod Bihari? He doesn't figure in this list at all.
Because that was vacant, your Lordship, serial number 13. You are 13. That is meant for PH. At that point of time, that was kept vacant. Subsequently, she was selected after lifting of the stay order. She was selected and appointment order was issued in its favor.
All right. Serial number 9. Full stop. There was one other person, Padmasini Khamari, who also applied in the SCBC quota, who figured in at serial number 6. Full stop. During the pendency of the writ petition, after the stay order passed by the Disability Commissioner was lifted, the post earmark for PA was in fact offered to the appellant Vinod Bihari Bagh,
Appointment order is at page 75.
and an appointment order was issued in his favor
On 17/9/2012.
on 17/9/2012. Full stop. However, for some reason, as explained by his counsel, Sri S.K. Dalai, he did not join on the pretext that the writ petition was pending in the court and that he needed a direction from the court to enable him to join. Paragraph. As far as Rajeshri Behra is concerned, since there were two posts earmarked in the SCBC category and she belonged to the SCBC, there should have been no difficulty in appointing her against that category because the candidate above her in the merit list, Padmasini Kamera, although belonging to the SCBC, was high in merit as far as the general category itself is concerned. We'll stop with there being two posts earmarked for females in the general category, with no other competing female candidate in the general category. Padmasini could easily have been accommodated against the UR category. Full stop. This meant that in the single post meant for female SCBC, Rajeshri Behra could have been appointed. Paragraph. The learned single judge, for some reason, failed to appreciate the above legal position that a candidate who may apply in the reserved category may on her own merit be able to be accommodated against the vacancy meant for the UR category if she had scored high enough marks, that is within the cutoff meant for the UR category, against the UR vacancy. Full stop. Consequently, the quashing of the appointment of Rajeshri Behra could not have been was unwarranted, since was unwarranted. Full stop. As far as the writ petitioner, that is the appellant in WA 41 of 2014 is concerned, the learned single judge is observed in para 19 as under, of the impugned order as under.
I'm sorry, my lordship, 47. This is 47. My lordship,
In writ appeal 47.
May I interrupt my lordship for a moment, my lord?
Yes.
The lordship again turn to page 36.
Yes.
There, my lord, Padmasri Kamari, the lordship, she, her mark is 54.060.
Which page reading now? 36.
36.
Ah.
The lordship, she, Padmasri Kamari, she has secured 54.600.
Right.
Then, my lord, your lordship, she, next, Sonali Panigrai.
Correct.
Why I am submitting so, my lord? Sonali Panigrai was selected under your female category.
Correct.
Your lordship, she,
So there's no other competing female.
I am coming that. Because two posts are you are under female category and you under your category, two female posts are.
Correct.
So first female category is Belamati Mahananda.
SC category.
No, SC, sir. She's SC.
Because by virtue of her merit, she will be selected under your category.
But
she has secured 59.333.
But she has not made a claim like that. Has she come forward to claim that she should be considered under the UR category? You can't now suddenly create a.
We have selected. Your lordship can find it from serial page number.
No. Is
93.
it your stand? Is it your stand that the UR was filled up by
Yes.
Belamati?
Yes, my lord. Page 93. Your lordship. That I want to show, my
There is no P 93.
General female Sonali Panigrai.
Only Sonali, you have not put Belamati there.
Sonali Panigrai was selected under your category.
Ah,
You are
one is still
female.
vacant. One,
Well-
you are female, is still vacant.
Then on merit, my lord, then she will
You
come.
don't create a ground now. This is
Bel-
not your stand.
Belamati will come under,
No, that has not been your stand.
because if merit will be taken into account,
You should have told the single judge that.
if the merit will be taken into account, Belamati will come to that UR category. Yes,
No, you did not take that stand, sir.
yes, ma'am.
So don't now take a stand that
No, that I
defeats
want
the whole
my-
case.
I want to my lord's notice only because if that merit will be taken into account, Belamati will come to your category.
You did not do that, but
My,
that para 19, just reproduce at para 19. Mr. Dalai, however, states that the Vinod Bhairahari Bagh was always prepared to join the post, and he did not do so only because the writ petition was pending. The court finds this explanation to be unacceptable. So there was no order by the learned single judge preventing Mr. Bagh from joining the post when it was offered to him. Full stop. It is the failure to do so is of his own doing, and therefore no fault can be found in the above observation of the learned single judge. Full stop. Nevertheless, it will be open to Vinod Bihari Bagh to take up if the post is still vacant by reporting to the authorities within a period of 2 weeks from the date of this order. Paragraph. The net result is that the writ appeal of Rajeshri Behra, writ appeal 41 of 2014 is hereby allowed, and the impugned order of the learned single judge, to the extent it quashes her appointment, is hereby set aside. She will be issued the appointment letter.
I'm already continuing, Your Lordship. I'm already continuing.
Oh,
I'm already
she's already continuing. No further order needs to be passed. Full stop. As far as
that order has to be confirmed. My appointment has to be confirmed.
and her orders be issued confirming her appointment within 2 weeks from today. Full stop. Writ appeal 47 of 2014 is disposed of with the directions already issued as far as Vinod Bihari Bagh is concerned. Right.
Grateful, Your Lordship.
My lord, may one thing, my lord, may I mention one thing. My lord, as per my prayer, my lord, while my lord, my prayer is, my lord, I have to be appointed since 2011, my lord.
No, you did not join, sir.
But
It's not
as per
possible
that
to give-
annexure 12, my lord,
It's not possible to give that
my lord,
direction.
kindly say, as per my annexure 12, I was offered on 17/9/2012. That is after 1 year.
You did not join, sir.
My lord, as per my
You should have
that-
joined first. You
My lord,
join and then
my
you
lord,
make the claim that my
my lord, that
appointment
was-
should be
my lord,
backdated.
that was under sub judice, my lord.
All right. That's all wrong understanding, sir. Right.
Sir, I am appealing for respondent note 4, 7 and 8.
All right.
And item 16, today I telephoned to the client to ascertain the status of the suit, my lord, because suit the year 2006. As per the instruction, my lord, suit is still pending for the hearing, and in the meantime, 2 defendants died. They are opposite patent 5 and 6, my lord. So I want to take substitute to.
No, not like this, sir. They must have died long ago.
Lord, in any
Tell us what the matter is about.
My lord, then you will also dispose of. I think my learned friend will not object to that. My lord, what has happened? The suit is pending, my lord. The learned civil judge in a review application, my lord, he has given an observation that you also may kindly see.
So how will a writ appeal be maintainable at all?
उमा जी
Raising
केस राव
numbers-
राधिका भाई जोगिंदर सिंह जी उमा जी केस राव राधिका भाई 86 जोगिंदर सिंह जी 2015 Supreme Court arising out of a civil suit. But how is a writ appeal maintainable, my lord?
This writ appeal per se, if you want to withdraw, you withdraw it. This
May permit. Permitted.
Counsel for the appellant seeks leave to withdraw the present appeal. Dismissed is withdrawn. All right.
Supplementary list item number 18.
None appears dismissal, not prosecution.
Supplementary list item number 19.
None appears dismissal, no prosecution.
Supplementary list, item number 20.
May I please, Your Lordship? My lord, the appellant has preferred this writ appeal against the judgment and order dated 25/3/2014 passed by the learned single judge. My lord, under Annexure 10. Lordship, kindly have a glance at the order of the learned single judge under Annexure 10. There is page 41, my lord. Lordship, may come to page 44, my lord, the operative part of the order. Last para, my lord. Considering the contention raised by the parties and on perusing the records, this court is of the view that the question which has been raised at this stage, that there is tampering of documents and perusal of the appeal memo filed by the petitioner before the joint director under Annexure 5. No such pleading is available except stating in para 6 of the appeal that he has been duly selected by the selection committee and given appointment by the secretary of the school managing committee to discharge his duties as a classical teacher of the school. The headmaster and Hindi teacher cannot prevent him to discharge his duty without following the due procedure of law. In that view of the matter, the order dated 10/5/2011 under Annexure 9 passed by the Joint Directors School Regional Director of Education Sambalpur has been passed after due application of mind by assigning regions after giving due opportunity of hearing to the parties. Therefore, this court is not inclined to interfere with the impugned order passed by the Joint Director School Regional Director of Education Sambalpur. Accordingly, the writ petition is dismissed. Lordship, may kindly have a glance at Annexure 7, my lord, the inquiry report, my lord. That is page 29.
Yes.
Well, he earlier approached this Honorable High Court, and the Honorable High Court was pleased to direct for disposal of his case, my lord. And Lordship, this is Annexure 7, the inquiry report of the Inspector of School Sambalpur, my lord. But they have clearly stated there is manipulation of records, my lord. Lordship, might kindly come to page 30.
Yes.
Last but second para, my lord. That in the process of inquiry of the relevant resolution number 24/7 at page number 99 dated 11/9/2007 and resolution number 26/7 at page dated 49/2007 were perused, the resolution at page 94 where Sri Sahu is said to be approved for appointment is not found in the resolution register, my lord.
So what?
That was intentionally kept.
It's not about manipulations.
And my lord,
no finding out manipulation.
My lord, I was appointed under this resolution, my lord. My lord, the managing committee, my lord, knowingly, intentionally, they have kept missing this.
There's no such finding like that, sir.
Lordship, last para, my lord, that on verification of the appointment letter, it is found that Sri Sahu and Sri Pradhan have been appointed bearing the same letter number 22/7 dated 14/9/2007. On the interrogation with the then President Sri Ananda Pradhan and Sri Secretary Karam Mahaku stated that they knew nothing about the applicant of appointment of Sri S. Pradhan. The signature in page number 100 of the resolution dated 14/9/2007 are not their own. However, the then President Sri A. Pradhan stated that the appointment of R. Sahu was made within the knowledge, and the signature of the said page is his own, my lord. However, when he was asked how Sri R. Sahu was appointed against the post of classical teacher, whereas Sri S. Pradhan was also appointed against the same post, he further stated that in the case of appointment of Sri S. Pradhan, no resolution or order of posting was made. But at the time of inquiry, the then secretary stated that his signature on appointment order and joining report are not his own, and they are forged one. The headmaster in charge and Sri Narayan Naik, assistant teacher PCM, who were present at the time of inquiry, stated that they didn't know about the appointment of both Sri S. Pradhan and Sri R. Sahu. But Sri Purushottam Pradhan, headmaster in charge, stated that Sri S. Pradhan is working in the school from 15/9/2007 to till date. Attendance and written statement of the members attended at time of inquiry attached for your kind information. At the time of inquiry, C.P. Pradhan, headmaster in charge, stated that there are no official records available in the office regarding advertisement and formation of school selection committee in connection with classical teacher of the school. My lord, these are the reports, and my lord, FIR was also lost at the Gaisilot, my lord, police station. And my lord, nothing has happened to that FIR, my lord, nothing has been done. And my lord, Annexure 11, my lord, Annexure 11 series, my lord, the then secretary and president of the school, they have admitted that the appointment of Sri R. Sahu, the Rudra Sahu, is within their knowledge. Under Annexure 11 series, my lord.
I am appealing to the opposite party number 6, ma'am.
No, so is that there's nothing? You have been duly appointed.
My lord, Annexure 1 is my appointment letter, my lord.
No, letter is true. There's no backing, no resolution backing up your appointment.
And my lord, there is no resolution backing up on the appointment of Annexure 6.
How does it help
number
you
6
that,
also, my lord?
How does it help you that he will not get the post? As long as you are not getting the post, you should bother for that.
My lord, Annexure 11 clearly states, my lord, Annexure 11 is the then secretary and president of the school, my lord. They have stated that my appointment was within their knowledge.
there is no resolution backing it up, sir. There is no resolution backing up your appointment.
Well, the president and secretary, they are admitting that my appointment was within their
that's the whole question. How was an appointment letter issued to you without there being a resolution concerning your appointment? That's the whole question.
My lord, school was an unaided one, my lord.
Whatever.
That time school was not
Everything
getting
has
any
to have
grant.
a procedure, sir.
My lord, managing committee has the
Yes.
authority to appoint me, my lord. And they
Correct.
have appointed me. And I was continuing, my lord.
No, there's no resolution for that, sir, to back it up. That's what the inquiry report itself shows.
Admittedly, my lord, there is no resolution, my lord. That I admit, my lord.
So you cannot succeed, sir. The challenge
But
the
the
present
statement of
petition-
the secretary and president shows that my appointment was within their knowledge,
the
my lord.
challenge the present petition is to an order dated 25th March 2014, passed by the single judge, dismissing writ petition civil 22502 of 2011, filed by the present appellant. By the said writ petition, the appellant questioned an order dated 10th May 2011, passed with the Joint Director, Regional Director of Education, Orissa, rejecting his representation for being issued, for being permitted to discharge the duties of a classical teacher by the management of the Panchayat High School, Jamutpally, in Bargarh, pursuant to an engagement order issued in his favor by the management on 14 September 2007. Full stop. The learned single judge considered the plea of the petitioner, of the appellant, that there had been a tampering of documents by the managing committee and that the appointment of opposite party number 6, Sri Sunil Chandra Pradhan, pursuant thereto, was therefore illegal. Paragraph. The learned observed in the impugned order that there was no pleading in the memo of appeal filed before the Joint Director to the effect that there was any tampering of documents, and therefore such plea could not be raised for the first time in the writ petition. Full stop. The learned single judge was satisfied that the Joint Director had passed the order dated 10th May 2011 after complying with the principles of natural justice, and declined to interfere with it. Paragraph. The concept appellant refers to the appointment letter, letter of engagement issued to the petitioner by the managing committee, and states that, on the other hand, there was no resolution backing the appointment of respondent number 6. Full stop. He drew attention to the dated 3rd June 2010, submitted by the Inspector of Schools, Sambalpur, Education Circle, pursuant to the first round of writ petition, that is, writ petition civil 72 of 2010, filed by the present appellant. Paragraph. The court has perused the said report. Full stop. Neither was there a resolution in the resolution register backing the appointment of the present appellant, nor any resolution backing the appointment of Sri Pradhan.
May I
Paragraph.
submit for the
As far as the appellant is concerned, he cannot go only by the order of engagement, since there was in fact no resolution backing such engagement. So therefore, the learned single judge cannot be faulted for not accepting the plea of the appellant that a direction should be issued to the school authorities to permit him to function as a classical teacher. Full stop. Paragraph. As far as respondent number 6 is concerned, even if his appointment is held to be not backed by resolution, it no way helps the present appellant to be so appointed. Full stop. Consequently, the court sees no reason to interfere with the impugn order of the learned single judge. The writ appeal is accordingly dismissed.
Maybe factually, I am supporting the judgment, but factually, your lordship has noted that there is no resolution in supporting me, but the resolution at page 100 supports me as per the finding of the joint director. That is read from the records. Page 38.
Page 30.
Page 38. That is the finding of the joint director. Lordship, 4 lines above the first pada, and page number 100 contains the resolution dated 14/9/2007, where the appointment of Sri S. Pradhan was made, which denotes the genuineness of appointment of Sri Pradhan. I am representing Pradhan, my lord. Appropriate party number 6.
No. Where is the finding at 38? Page 38?
Page 38, 4 lines above the first pada. Well, towards the last end of the pada, penultimate 4 lines of the first pada.
I see. All right.
And page
Nevertheless, is a finding by the joint director. Just add this line. On scrutiny of the resolution register,
page number 100
that there is a resolution dated 14 September 2007, under which the appointment of Shri Pradhan was made. Which perhaps justifies his appointment. All right. That's it. Just add this one line. Okay.
Item 21.
My lord, I may be permitted to withdraw, my lord.
Concept of the appellant seeks leave to withdraw the present appeal. Dismiss this withdrawal.
Item 22.
Lord, may I please, lordship. Lord, this impugned order of the learned single judge at page 21 was passed without any notice to us. That I am for the oil company. There is a jurisdiction which will not extends up to 15 kilometers, 0 to 15. That is the jurisdiction of a distributor for a LPG connection. That there is an existing HPCL outlet distributor. That the collector's instance you give to him, notwithstanding the the jurisdictional issue. So the honorable single judge disposes of that you comply with the direction, you comply with the collector's direction. We don't have any objection, but the company's policy doesn't permit us, permit the distributor to supply. There is another outlet, distributorship, I mean, of Hindustan Petroleum Corporation Limited, HPCL. That Millard annexure B/2 at page 9, page 31. Your lordship may kindly turn to page 31, Millard. Para 3 from the top, from the below, Millard. In view of the above, it is intimated that IOCL is not, Millard, the para 2, your lordship may. For Messrs DSMS, Jagatsinghpur, such operating area is limited to 15 kilometer radius from the 0 mile of Jagatsinghpur town. However, connection against incoming TV may be released even if the TV holder is residing outside the operating area and no other distributor is catering to that area. Further, as per the extant policy of Ministry of Petroleum and Natural Gas, whenever a new distributor is commissioned in any market area, extension counter of any other distributor falling within the operating area of the newly commissioned distributor is required to be closed immediately after handing over of existing customers to the newly commissioned distributor. This was also discussed during the meeting convened by the then collector, District Magistrate on 17/4/12. In view of the above, it is intimated that IOCL is not mandated to permit release of new LPG connections beyond operating area of Messrs DSMS Jagatsinghpur or any other distributor. However, we would like to apprise you in this regard that a new rural distributor under the category of Rajiv Gandhi Gramin LPG Vitarak has been done by HPCL in the said Ersama area, and 26 applications for new LPG connection may be transferred to the said distributor so that the concerned applicants can avail the LPG. But I fail to understand when there is an existing distributor of another oil company.
No, Mr. Acharya,
My lord.
in the impugned order, it says that the earlier writ petition 7007 of 2012 had been disposed of on 16th May 2012 by an order. And that order you did not challenge. That order you did not challenge.
To examine and consider the claim. There was
correct,
no
but that order you did not challenge. That was also ex parte.
That was ex parte. There was no direction in that period. That just to examine and dispose of. Then your lordship may kindly turn to the call. These letters were not produced before the honorable single judge by the petitioner. That is your annexure. Your lordship would find AY2. The area manager, he writes it, I was still Bhubaneswar Swansu in inviting a reference at page 29. Discussion held on 8th April 2013 as the petitioner demands for release of new LPG connection in favor of the applicants wherein applied to DSMS Jagatsinghpur, which may be considered. Necessary steps may be taken at your end to provide them new LPG connection through appropriate LPG distributor stroke HPCL under this jurisdiction. It can be done by any of the companies, because if we do not have the distributorship within that area, we can provide Millard, because the distributor may face difficulty. So nowadays, I don't think Millard after 14 there may be lots of changes. I don't know what is the current position, because it is being listed after 8 years. Let me.
Was there a stay of the order of the single judge?
Millard,
no contempt proceedings will continue. Okay.
No, Millard. I don't think after Ujjwala they may be providing free of cost. So I don't know what is the current position. Let me take fresh instruction. Your lordship may call it up.
No need, sir. We just dispose it all.
So let the collector consider afresh. Let both the parties be heard afresh.
All right. You say the challenge in the present appeal is to two orders dated 30th January 2014, passed by a single judge in WP Civil 939 of 2014, and the subsequent order dated 4th April 2014. In Miss Case number 4080 of 2014 in the same writ petition. Paragraph. The aforementioned writ petition civil 939 of 2014 was filed at the instance of by respondents 1 and 2 agreed by the inaction of the present appellant, that is Indian Oil Corporation Limited, bracket IOC, bracket IOCL, bracket, in not giving them LPG connections, despite an order dated August 2012 by the Collector and District Magistrate Jagatsinghpur. In that regard, paragraph. It must be noted that the above writ petition was the second round of litigation. In the first round, the said two applicants, said two respondents, had filed writ petition civil 7007 of 2012, which was disposed of by the single judge on 16th May 2012, with the direction to the collector to consider the representation and pass appropriate orders. So pursuant thereto, the collector issued a direction on 17th December 2012, directing IOCL to supply the requisite number of LPG connection to the DSMS Jagatsinghpur. Paragraph. Mr. Pitambar Acharya, full stop. When the above direction was not complied with, the second writ petition was filed, which has been disposed of by the first impugned order dated 30th January 2014. Directing IOCL to comply with the collector's order within a period of 4 weeks. Paragraph. Miss case number 4080 of 2014 was filed by IOCL, seeking recall of the above order dated 30th January 2014, essentially on the ground that no notice had been issued to IOCL before the said order dated 30th January 2014 was passed. However, this application was dismissed by the second impugned order dated 4th April 2014 on the ground that IOCL had not challenged the earlier order dated 16 May 2012 in writ petition civil 7007 of 2012. Paragraph. Mr. Pitambara Achyalal and senior counsel appearing for the appellant IOCL points out that there was no occasion for IOCL to challenge the first impugned order dated 16 May 2012 in WCP Civil 7007 of 2012, since it was an innocuous order, merely requiring the collector to examine the representation made by the writ petitioners. Full stop. That in no way prejudiced IOCL as such. Paragraph. He, however, points out that as far as the collector's order is concerned, that date dated 17/12/2012 is concerned, it is fundamentally flawed, since the jurisdiction to which the writ petitioners operated did not fall within the region served by IOCL. And there could be other suppliers of LPG, who should have been asked to provide the LPG cylinders. In any event, he submits that this fact was perhaps not even present to the mind of the collector when he passed the order dated 17/12/2012. Full stop. He further submits that even the order dated 30th January 2014 of the learned single judge was passed without notice to IOCL, which is what necessitated the filing of an application by IOCL for recall of that order. Paragraph. Having considered the above submissions in light of the orders passed by the learned single judge, this court is of the view that the orders can be sustained in law. Impugned orders can be sustained in law, since both fail to appreciate the fundamental principle that IOCL ought to have been heard before orders adverse to it could have been passed either by the collector, Jagat Singhpur, or even by the learned single judge. Full stop. On that short ground, both the impugned orders are hereby set aside. Full stop. I think we'll restore writ petition, I think, to the file of the learned single judge. That may be better. Writ petition civil 939 of 2014 is, however, restored to the file of the learned single judge, where it will be listed for directions on 26 September 2022, on which date IOCL will remain present through its counsel before the learned single judge. Full stop. Since the original writ petition has not appeared in this writ appeal, the learned single judge will proceed in the matter after issuing notice to those writ petitioners if they're not present before the learned single judge on 26 September 2022. And if they fail to pursue, if they fail to appear even despite such notice, to pass appropriate orders in accordance with law. The writ appeal is disposed of in the above terms.
Fair enough, I am more blessed.
Yes.
Supplementary list item number 23.
My lord, there is noting as per SR dated 6/9/2014, my lord, writ appeal may not lie in view of the judgment passed in
So
AIR.
you can withdraw it. You say, since in view of the decision in AIR 2009 Orissa 46, the writ appeal is not maintainable, and accordingly, appellant counsel, the appellant seeks to withdraw the writ appeal to seek other appropriate remedies in accordance with law. Dismiss is withdrawn with liberties paid for.
Item 24. 24.
Item 24, my lord, on behalf of Mr. Satyavata Mahathi, I pray for 3 weeks after. He's on accommodation.
No, no, no. We are not accommodating like that. You tell us what the
His
appeal is
mother
about.
expired since
Oh, when did that happen?
just 3 days back.
All right. Counsel for the appellant is stated to be.
Respondent.
Respondent side. This is for the appellant, sir.
I am for appellant.
You first make out your case.
My lord.
Ah.
My lord, order that Annexure 1 is under challenge, my lord. That this petitioner was initially appointed on the rehabilitation scheme, my lord. And as per my lord, Annexure 2, my lord, so lordship will see, he was directed to that is your page 17, your lordship may kindly see. The candidate should give an undertaking to the effect that he should serve the Orissa Lift Irrigation Corporation Limited for minimum period of 3 years, my lord. Thereafter, I have been continuing, my lord. My lord, I had been appointed on the engaged on 31/8/1987. In 2001, my lord, one model voluntary retirement scheme was introduced, my lord, and that was accepted by OLIC in the year 2002, my lord. And there was an 8/11/2002 that modality prepared that fixing 15/1/2003 as the last date of application for VRS, my lord. Not that I had applied for the application for VRS, my lord, but subsequently on 15/1/2003 I had applied for VRS, my lord. But on 31, on the next day after 15 days, my lord, I had filed an application for withdrawal of the same, my lord. Though that has not, as per the scheme, my lord, though that has neither been rejected nor has been accepted, my lord.
No, it was accepted. What do you mean not accepted? It was accepted, you got the amount, you received the amount also.
No, my lord, that part is settled, my lord, but that part, entire amount is not received, my lord.
No, you
and
received some part of the amount or not?
My lord.
You should not have received any amount.
Part amount is paid, my lord.
How can you accept in part like this? If you're keen that you're withdrawing your resignation under VRS scheme, you should not have accepted any part of the amount.
The matter was under stay operation before this honorable court, my lord. That was continued. If your lordship will kindly see, that is in my lord, page 22, your lordship may kindly see. Page 22 and 23, my lord.
Yes.
Page 23, for lordship will see, they have prayed for whether we will relieve the person concerned or not, my lord. And
you're not concerned with all that, sir.
My lord.
The prayer in your petition is that you should be asked to be taken back. That was your prayer.
My lord, as per the scheme, my lord, this should they should have given communication, my lord, as per the rejection or acceptance, my lord. That
No, you should not have accepted the VRS, sir.
That
when they sent you the money, you should not have accepted.
My lord, received on different circumstances, my lord.
No.
For long delay, my lord, that was not paid.
No.
And if your lordship will see their affidavit, my lord, they said on one check I had given for as per the scheme, my lord, and on another area amount was paid, my lord.
Yes.
But no such full amount is not paid till date.
All right.
And if your lordship can say, my lord, at best, let them calculate, let them say how much dues are pending before them, my lord.
Let them see. That's not scope of this writ petition. You say the present appeal is directed against an order dated 10th April 2014 passed by a single judge dismissing writ petition civil 5323 of 2003 filed by the present appellate. Paragraph. The prayer in the said writ petition was for a direction to the opposite party state.
But my lord,
to post the petitioner in any government establishment and to give him all the benefits under the scheme applicable to government employees. Paragraph. The background facts are that the petitioner was employed as a junior clerk as a measure of the Rehabilitation Assistance Scheme, bracket RAS, formulated by the government, after the death of his father.
Number 2, my lord,
who was working as an ex-head clerk in the Department of Water Resources. Full stop. The stipulation under which the appellant was appointed was that he should serve in the Orissa Lift Irrigation Corporation Limited (OLIC) for a minimum period of 3 years. Paragraph. A voluntary retirement scheme (VRS) was floated for all public sector units (PSUs) of Orissa, including OLIC. Full stop. Admittedly, the appellant opted for the VRS within the time stipulated, that is before 15th January 2003. Full stop. According to the appellant, he then realized that the said VRS is not applicable to him since he was appointed under the RAS, and therefore before the acceptance of his option under VRS, he submitted a representation seeking to withdraw the VRS option and asked that he be posted in any government establishment. Paragraph. When he did not hear from the opposite parties, he filed Writ Petition Civil 5323 of 2003, in which an order of status quo was passed on 28th May 2003. That interim order did not continue beyond 28th August 2003. And he was relieved ultimately with effect from 25th February 2004. Paragraph. Although the contention of the appellant before the single judge was that he should have been permitted to continue in government service since he had withdrawn from the VRS. But the learned single judge noted that, open quotation, VRS of the petitioner is already acted upon by paying the required amount, which he had acknowledged with Annexure D2 at serial 14, where the VRS amount has been received. And as the VRS amount has been acted upon, at this stage, there is no question of withdrawal of the same, unquote. Counsel for the appellant sought to contend that the amount accepted by the appellant was not the entire amount, and therefore should not be construed as if the appellant had not withdrawn from the VRS. Full stop. The court is unable to agree with the above submission. Full stop. If the appellant was serious about withdrawing his option under the VRS, then he should not have accepted any amount offered to him pursuant to his opting for the VRS. Full stop. At the least, he could have accepted it under protest, which he obviously did not do. Full stop. The above conduct of the appellant disentitles him to contend that his withdrawal from the VRS should have been accepted and he should have been given a posting in any government establishment. Paragraph. The court is unable to find any error having been committed by the learned single judge in passing the impugned order. The appeal is accordingly dismissed.
Supplementary list item number 25.
As item 25 is a suo motu PIL.
It is initiated in compliance of Honorable Supreme Court's order, my lord. Personally, kindly this Honorable Supreme Court's order. That is there in the first year. Because a writ petition was filed before the Honorable Supreme Court, alleging that the about the occupational hazards of the workers working in coal-fired thermal plants. So there was I am appearing for opposite number 5, that is NIOH. NIOH is National Institute of Occupational Health. that NIOH was asked by the Honorable Supreme Court to submit a report, because that is the recommending, this expert body, the recommending body. So we submitted a report. So basing on the report, my lord, the Honorable Supreme Court, Lordship, kindly see the order of the Honorable Supreme Court. Page 18, Lordship will
Page 18.
Page 18, para 16 of the Supreme Court judgment, my lord. Para 16, 1/6. Probably that is there, is attached to the attached first. You got it, my lord? Para 16. May I place the para 16, my lord?
No, 1 minute, sir. Let's try and locate the place.
Oh, I'm sorry.
January 2014, order of the Supreme Court. Does any of you have the judgment of the Supreme Court?
Yes.
It is immediately after the cause statement.
I am appearing for opposite partner 6. I pray some time to file an affidavit. In the meantime, what are the steps we have taken for improvement of the health condition of workers? Though our plant is strictly not a coal-fired thermal power plant.
Who are you appearing for, sir?
Opposite partner 6. Tata Sponge Iron Factory
No,
Limited.
no, Nalco, is it?
Not OP number 6.
Who's OP number 6, sir?
Tata Sponge Iron Limited.
Please say that.
About 60 industries who have been read as parties, notice. 61 industries, those who are operating the coal-fed power plants.
Kindly see the Supreme Court order so that let's have an idea about the case, my lord.
Right.
Para 16, though there is a long version, but para 16.
I think, my lord, page 18 would be para 16.
Right.
My learned senior is pointing.
Correct. Para 16.
May I place it? We may notice the recommendations made are to be welcomed, but how far they are put into practice and what preventive actions are taken to protect the workers from the serious health hazards associated with the work in CFTTPPS call for serious attention. Many workers employed in various CFTTPS are reported to be suffering from serious disease referred to earlier. What are the steps taken by the CFTPPS and the Union of India and the statutory authorities to protect them from serious health hazards and also the media treatment extended to them, including compensation, etc., call for detailed examination. We notice that CFTT are spread over various states in the country like Uttar Pradesh, Chhattisgarh, Maharashtra, Andhra Pradesh, and so on. And it would not be practicable to for this court to examine either CFTPPS are complying with the safety standards and the rules and regulations relating to health of the employees working in various CFTPPS throughout the country. We feel that these aspects could be better examined by the respective high courts in whose jurisdiction these power plants are situated. The high court should examine whether there is adequate and effective health delivery system in place and whether there is any evaluation of occupational health status of workers. The high court should also examine whether any effective medical treatment is meted out to them. We therefore feel that it is appropriate to relegate it to the various high courts to examine these issues with the assistance of state government after calling for the necessary reports from CFTPPS situated in their respective states. For the same purpose, we are sending a copy of the judgment to the Chief Secretary of these respective states as well of High Courts, and H is our Orissa High Court. Total 18 High Courts are there. Para 19. Report of National Institute of Occupational Health, NIOH, titled Environment, Health and Safety Issues.
This case was listed once on 10th December 2014.
Yes, not only once. No,
after that it is coming up only today.
Yes. No, it was listed on. Yes, my lord.
Taken up.
For 8 years, listed even once. So what is the stand of the state government? You are the most important entity here.
My lords, this statement in fact had filed one affidavit. It was an instruction. My lords, we were asked to ascertain the number of these coal-fired thermal power plants.
No, that is okay. That's only the first.
That, my lords, nothing has.
Subject to what my learned friend says, what I would recommend, because there's a statutory body which is the inspector of factories and boilers who looks after these health hazards and health issues of the factories. So if they can be directed, they can take it like all the centralizedly, they can take the reports. And then they can come back to the court, and if there is any lacuna, the companies can ask to fulfill it. Because otherwise it will be a too generic term, or the general term where nothing can actually come out of it.
No, in fact, they could think of setting up some commission.
Yes, they can.
To deal with claims of workmen.
To deal with the
claims of work. You see, the present petition was registered in this court pursuant to the judgment dated 31st January 2014 of the Supreme Court of India in writ petition civil 79 of 2005 bracket Occupational Health and Safety Association versus Union of India, unquote. Stop. In the said writ petition, the issue was regarding the health hazards faced by workers in coal-fired thermal power plants, bracket CFTPPs, bracket, spread over different states in the country. Full stop. It is pointed out that although a plethora of legislation, including labor welfare legislation, were in place, there was very poor implementation of the measures contained therein. Full stop. It was pointed out that several of the workers in the CFTPPs were suffering from lung function abnormalities, skin diseases, asthma, pulmonary function test abnormalities, and so on. Paragraph. A report had been called for by the Supreme Court from the National Institute of Occupational Hazards, bracket NIOH, NIOH. Full stop. That report was submitted by the NIOH after studying the working of the CFTPPs in 2011. Full stop. Among the states identified as having functional CFTPPs, Orissa was one. Full stop. By the said judgment dated 31st January 2014, the Supreme Court asked the Secretary General of the Supreme Court to make available to the Registrar Generals, bracket RGs, bracket of the High Court, the various states, copy of the report of the NIOH to enable the High Courts to examine the issues projected in the judgment independently. Open quotation. After calling for reports about the CFTPP's functioning in their respective states, unquote. Paragraph. In the order dated 10th December 2014, the order dated yeah, 10th December 2014. The court proposed a comprehensive scrutiny to be undertaken. And requested the state opposite party to assist in the process of open petition, identifying and cataloging the issues on priority basis, unquote. However, it appears that thereafter the petition was not listed and it has come up in its own turn today. So stop. It must be noted here that as many as 61.
No, it's 57, Miller.
67, is it?
57,
61. 61.
As per the report, 61 industries.
There are
There are
state
61
operating
industries
Yes.
having CFTPPs in Orissa, which have been identified. And they've all been arrayed as parties to the present petition.
Sorry, may I just submit, they're not identified as violators. They're
Having CFTPs. Some of them have filed affidavits for the sport. Full stop. Some of them, including NALCO, bracket opposite party number 36.
54 also, NTPC, TSTPS, Kanya.
I'm 58.
54 is also filed.
Visa Steel Limited, bracket opposite party number 11. Jindal Stainless Limited, opposite party number 24.
I'm for OP 58.
54
Maithan Export Limited, bracket opposite party 19. NTPC Limited, bracket opposite party number 54.
I'm for opposite party number 34. Your Lordship.
No, if we filed an affidavit.
No, I have not filed.
No, we're just thinking of have all filed affidavits. Stop. Paragraph. The court would like the state government to file a comprehensive affidavit of the steps it proposes to take in the first instance, to undertake a survey of all the CFTPPs in the state of Orissa to address the issues highlighted in the report of the NIOH, to identify workers in any of the CFTPPs who are suffering from any of the health hazards highlighted in the report of the NIOH, and prepare a comprehensive list industry-wise of such workers. 3, explore the possibility of setting up an independent mechanism which can adjudicate the claims of such workmen for appropriate remedies and reliefs, for appropriate reliefs in accordance with law. The court expects the state government to undertake the above exercise within the framework of the existing laws, including the labor and environmental laws. This comprehensive affidavit with proposals of the state government be filed within a period of 4 weeks from today.
Let's see, 6 weeks.
6 weeks, all right. And in any event, not later than 1st November 2022, with an advance copy to consider the parties. Full stop. List on 23rd November.
May I prefer copies of the affidavit filed by the respective parties? I do not have copies of the affidavit filed by the...
All the affidavits, copies of the affidavit, actually obtain you say Mr. Manoj Mishra, learned senior counsel appearing for NIOH, is permitted to collect a soft copy of the entire paper book on a pen drive from the registry.
Yes, that will be better.
All other counsellors also permitted. Likewise.
On behalf of OP number 6, I pray some time to file an affidavit that we are not a coal-fired thermal plant.
So you're permitted, whoever wants to file an affidavit, you say in the meanwhile, any of the companies who want to file affidavits are permitted to do so. Right.
Right. Supplementary list item 26.
None appears. This was an opposition.
Supplementary list item 27.
My lord, item 27, I may be permitted to withdraw the
counsel petitioner seeks leave to withdraw the petition. Dismiss as withdrawn.
Supplementary list item 28.
None appears. This was an opposition.
We are for the railway, my lord.
All right. All right.
Supplementary list item 29.
May I please your lordship, this is a PIL matter, my lord. And notice has been issued in this case, my lord. As yet, I have not received the counter, my lord.
No, what is it about, sir?
Matter, my lord, relates to pollution. I have no brief, my lord.
No, you can go to the NGT, sir. You say for the issues raised in the present petition, it will be open to the petitioner to approach the National Green Tribunal. In accordance with law, the petition is disposed of. Right.
Supplementary list item 30.
My lord, what happens, sir?
You go to the NGT, sir. Yes.
My lord.
Item number 30.
Item number 30, this is a show motor PL, my lord.
All right. Just see.
Lordship directed for filing an affidavit, and that affidavit was filed on 6th of August of 2019. I must pray your lordship may grant some more time for filing of latest position.
What's the issue, sir?
With regard to the availability of playground in the schools and appointment of teachers.
Or an updated affidavit shall be filed by the state government on or before 1st November 2022. List on 30th November. 15th November and 30th November.
Supplementary list item 31.
None appears. This was not possible.
Supplementary list item 32.
May I please your lordships? I am in a petition in item number 32, my lords. I am through Bishi. This is on PIL, my lords. In this case, about 3,000 families, houses having no drainage facilities, for which around the year, my lords, they are being inundated with the drain waters. For this, my lords, they have approached different authority, and CDA has prepared one plan, that is scheme number 2, and I have given the copy of the plan at page 11, my lords, of my writ petition, my lords.
Yes.
In that plan, my lords, they have provided road and drain facilities, which is lacking in this area. And since the Cuttack Municipal Authority didn't take any action, the one civics committee filed one OJC, that is another PL, that is OJC number 7832 of 2011. I have annexed it at page 18 to 21, in which in the counter, the municipality has expressed the paucity of fund, for which the Honorable High Court directed the government to place the fund, my lords. But till date, my lords, no steps has been taken. As a result of which, my lords,
did not file anything for 8 years, sir. That order was passed on 10th May 2007.
My lords, we have been approaching the authority time and again.
You know that mere approaching is not enough, sir. 8 years you can't keep approaching.
My lords, it is a problem of last 35 years, my lords.
No, but how diligently you take steps is also important, sir.
My lords,
you seem to sleep over the matter.
No, I have
every 8 years you wake up.
My lords, I was taking.
It has got listed today in its own turn.
My lords,
otherwise you have not made a mention. You have not filed an application.
My lords, previously I was taking steps, but after this COVID, because of my health problems, I could not take any steps.
Sir, this was not listed. Sir, COVID happened in 2020. This petition was last listed on 10th February 2016.
My lords, your lordships.
There was no COVID then.
My lords, your lordships, kindly see, we have also filed another interim application, that is 3270/2020, where we have also mentioned the same problems. My lord, is time and again it is aggravated. Every year, even today, my lord, some of the roads are inundated with drain water, my lord.
Sir, you file a comprehensive petition afresh,
yes,
giving the current position,
yes,
we will take it up.
Yes, my lord.
Counsel, the petitioner seeks leave to withdraw the present petition with the liberty to file a comprehensive petition, updating the latest status. This post office withdrawn with liberty is paid for. All right.
Yes, madam.
Supplementary list item 33.
May I please your lordship, madam, PIL, the file.
But sir, item 32, sir, I am for the Cuttack development.
All right. Yes.
So
you have to switch on the mic.
Yes, madam. The application I filed with PIL regarding after Dhamra port has been taken up.
Yeah, it's all right.
Yes. At the Dhamra port has taken up by development, the land mafias has procured the land in the fake company
And by forging the death certificate, legal aid certificate, as well as all the land of the farmers without giving any amount to them, my lord. In my allegation, see, counter has been filed by the police appeal number 2. You'll also may kindly see counter of opposite point or 2, my lord. You'll also may
FIRs have been lodged already, sir.
Yes, ma'am.
Yes, sir.
FIRs are already lodged.
No,
Follow up on the FIRs, sir.
Yes, ma'am. You will also may kindly see. The FIR has been stated that the only investigation has been gone, my lord. But you also may kindly see. Admittedly, my lord, the forge has been made in respect of the legal aid certificate, death certificate, the person, those who are exist in the locality, and they have been shown as a death and land has been.
Sir, nothing, no steps. Sir, the problem is, sir, this matter was listed last on 25th February 2016. That was the only day on which it was listed.
My lord,
for the last 6.5 years, no finger has been lifted to get the matter listed, to follow up on issues, nothing.
My lord, kindly see, para 4, my lord.
I doubt any of these PIL petitioners are serious about anything at all, sir. All these matters are coming up because I have asked them to list all these matters. Nobody has mentioned any of these matters. If they are genuine PILs, how can lawyers sleep over it for 6 years?
My lord, you'll also may kindly see.
How is it a genuine PIL then?
Because, my lord, the poor person are involved.
Everybody is poor, sir. In fact, this is a service done to poor people. For 6 years, you file a petition and for 6 years, sleep over it. Forget about it. You think you're helping poor people. What kind of service are we giving poor people then?
What I respectively submit, my lord, as per the affidavit filed by the police, my lord, some of the cases has been taken.
So you must have, see, a PIL petitioner is not meant to simply come and deposit a petition in court and go off to sleep. And anybody asks a question, you give only one argument, these are all poor people. Any argument. No law, no facts. The only argument is everybody is poor. How does it help the court to progress in the matter, sir?
Substantial petition filed by.
There is no placing of the complete facts. There's no placing of the legal position.
I have been
very difficult for the court to make progress in these kind of matters, sir. You have to be diligent. You'll have to bring out instances.
Earlier, my lord, only urgent matter has been listed because of your lordship's matter. All the matter has been coming.
Sir, if it is a really urgent matter, there's no
filed the memo that has not been listed.
So in the last 1 year and 9 months,
yes,
have you mentioned? Honestly, tell me, have you ever mentioned even one date to me?
No, man.
Then what is the point in saying memos were filed? In the last 20 months, nothing has been done.
Filed, my lord.
No, in the last 20 months since I took over, I don't remember a single day when this matter has been mentioned before me. And you yourself admit it was not.
Fact remains, my lord, you will also see that the affidavit filed by the police itself showed that only some cases they have taken the account. You will also may kindly see. Para 4.
Yes.
The register shall deed, it submitted the Chandwali PS case number so and so against 12 persons and investigation going on. Similarly, with regard to the preparation of for shall deed, Chandwali PS case number so and so registered under section 467, 468, 472 and 420, 34 IPC under answer B/2.
So there are 3 FIRs. You'll have to follow up on what has happened in each of the FIRs. It's for you to do it, sir.
Not only 3, my lord. Number of FIR has been registered. You'll also kindly see in para.
And then there's 7. A civil suit.
7 and para 8, my lord.
So they all becomes really complicated questions of fact, sir. If you're in one PIL, one PIL, if you're going to start dealing with every forced sale deed,
no, my lord.
We'll have to set up a special court only for this.
What I pray, my lord, what I prayed, lordship, special investigation team should be formulated to conduct all these things. Well, that is the prayer I have made. You also may kindly see my prayer in the and by virtue of my endeavor, our endeavor, my lord, all this has been come to line. You will also may kindly see. I have given. You will also may kindly see at page 75 of my
sir, but application. You people are not diligent, sir. You wake up one fine day.
I bow down, my lord.
You file a petition. You forget about it. Have you followed up with the police? When did you get this counter affidavit? When were you served a copy of the counter affidavit, sir? 4th May 2016.
That
Right?
has been filed on the
4th May 2016, you got a copy of the counter affidavit. That's what the endorsement here says. Have you ever gone to that police station, spoken to that IIC and told him, sir, what is the current status of investigation? Have you ever done?
Subsequently, also we have endeavored that the allegation which has been made who are party in the writ application, OP number 3 to 4. Those
your Dhamra, Chandbali, Nagarika, Suraksha, Mancha, right?
Yes, madam.
What steps have you taken by approaching the police, filing an RTI, finding out the current status of investigation?
All these documents, my lord, that has been obtained from the RTI, lordship. Under
Sir, this is a counter affidavit filed by them.
Yes, madam.
They have enclosed with the counter affidavit copies of the FIRs.
Yes, madam.
Have you, as the body, gone to the police and found out what is the current status of investigation?
Yes, my lord. We have pursued that so far as the person who was involving and doing all these things, and we respectively humbly state that they have also made party in this writ application.
Sir, I don't think you're answering the question. You come to the counter affidavit.
Yes, madam.
What is annexure A by 2?
A by 2 is the FIR, madam.
My question to you is, what follow-up action you took on this FIR? Did you go to the police? Do you meet the IIC? Do you find out what is the current status of investigation? A by 2 is an FIR, B by 2 is an FIR, C by 2 is an FIR. Have you, sir, after the counter affidavit was received by you,
yes, madam,
what steps did you take?
My lord, they have at that point of time.
Sir, I am again repeating, after the counter affidavit was received by you,
yes,
what steps did you take? What letters did you write? Nothing.
I have
nothing, sir. That's the point.
But the
you did nothing. Why should, at the instance of a disinterested petitioner like this, the court interfere? Why should we break our heads when you are not interested?
This
is the greatest disservice to people whom purportedly for whom you are beginning to stand up for. That you will file a petition and forget about it.
Fact remains, my lord, admittedly, my lord, they have.
It's very unfortunate, sir. It's really unfortunate.
The petitioner should not be tried to the right in view of the.
Who was appearing?
But the OP number 3 and 4, though is appearing, but no counter has been filed, they have not given in stand. I have specifically alleged against them. OP number 3 to 6, madam. I have specifically alleged with the person who was outside from the state of Gujarat. He established that fraudulent company and sale deed has been executed in their name.
Let us see how serious you are, sir. Let us see how serious, what work are you prepared to do? How big is an organization? How big an organization three of you are petitioners, correct?
Yes, my lord. I'm an NGO.
How many people are there in your NGO?
I'm about in my para 2 years.
No. How many people are there? You know, sir. You are representing them. You should know. How many members are there in your organization?
But that
you have no idea.
But because my learned senior Mr. Rai has been filed this application, he has no more. And taken into account that fact that
I think the court made the mistake of listing it.
No, my lord.
Otherwise, you had gone to sleep. We unnecessarily woke you up. It's our fault. You would not have been troubled about this petition at all if you had not listed it. I'm seriously thinking why we should continue with it at the instance of somebody who's disinterested. Are you really interested, or it's a burden for you, this petition?
No, my lord.
If you're really interested, can you find out from this whoever is representing what steps he's prepared to take to follow up and file before us a comprehensive affidavit?
One new time, my lord, 10-day time, my lord, I will be. And you also already know that the case is also registered.
Let me make it very clear, sir. If these petitioners are not interested in pursuing these petitions, they better frankly say that, and we can then know how to deal with these issues.
Today, my lord,
This is a great disservice. This is a great disservice.
I will take the instruction, Your Lordship.
You see, the present petition was filed way back in 2016, complaining of single quotes fraudulent land mafias, unquote, operating in and around the Dhamra port area. Full stop. Pursuant to the notice issued in the present petition on 20 February 2016, bracket, after which the case was never listed except when it is listed today on its own in its own turn, bracket. A counter affidavit was filed by the police, by the local police, way back on 4th May 2016. Paragraph. The petitioner does not appear to have shown any interest in the matter thereafter, since no rejoinder has been even filed to that affidavit. Full stop. The said counter affidavit encloses copies of 3 FIRs registered in the Chandbali police station in Bhadrach district. Full stop. Paragraph. If the petitioners are really serious about pursuing the present petition, they should, before the next date, file a comprehensive affidavit after finding out from the inspector in charge, bracket IAC, of Chandbali PS, the current status of each of the above FIRs. Full stop. The IIC will extend his full cooperation to the petitioners if they approach him in this regard. Full stop. Independently, the IIC of Chandbali PS will file an affidavit in this court updating the current status of the investigation of those cases. Full stop. List on 24th November.
Supplementary stand 34. Item number 34.
I'll take off next week, my lord.
What is the matter about you? Tell us, sir. Kindly tell us what the case is about, sir.
So, PIL, my lord, public land encroachment.
Sir, again, same story. Nobody is interested in these matters, sir. Actually, only the High Court seems to be interested. No petitioner, no lawyer, nothing. Nobody is interested.
The counter is not been filed, my lord.
It won't be filed, sir. Since you yourself are uninterested in the matter, nobody is going to be interested.
I have several times I have given memo, but matter did not listed.
Sir, I have been here, Chief Justice, since January 2021. You tell me, did you mention it before me?
I'll let it next week, my lord. No.
Sir, don't simply say that. We are not here to simply grant adjournments. You see the petition which was listed last. This petition filed in 2016.
Item number 36.
36, my lord. So PIL, notice are issued that none of the opposite parties filed any counter affidavit, my lord.
What's it about, sir?
My lord, it is opening up a petrol pump within the 100 feet from the interstate gate, my lord, toll gate. And it is against their own guideline of the road and national highway, my lord, that is annexure 1. I'll have a glance to the page.
So this petrol pump is now functioning for more than 6 years now?
Working.
It's working.
There's no interim order.
There's no interim order.
What's the point, sir? The petrol pump in question has been operational for more than 6 years now, with no interim order having been passed by this court. So suppose there's no reason why at this stage it should interfere.
Well, if I kindly glance to the order dated 6/12/2016,
yes,
as per the direction of this honorable court, I have deposited 25,000, my lord, so to show the bona fideness. That may be
the amount deposited by the court with the court by the petitioner be refunded to the petitioner together with interest accrued thereon forthwith. Right. The petition is disposed of.
Supplementary item 37.
My appearance for OP number 7 may be taken.
Yes.
OP number 6, sir. 6.
Item 37.
None appears dismissed from opposite.
I am appearing for Inspector 1. Item 38.
My lord, on behalf of RRT, the matter has become infructuous, my lord.
Counsel petitioner states the petition has been rendered infructuous. It's disposed of as such.
Item 39.
Well, 39 here, my lord, the relief claim has already been allowed by the government.
My lord, I'm sorry, my lord.
Counsel the petitioner states that the petition has been rendered infructuous. It is disposed of as such.
My lord, I'm sorry to mention. In item 38, my presence may mention. I am for CHSE.
All right.
Item number 40.
Memos taken on record. No instructions dismissed. Not possible.
Item 41.
None appears dismissed. Not possible.
Item 41. Here means the PIL matter. Petitioner is the villagers of Nevalo. They have filed a representation before the Tahsildar, Nishankuil, under Annexure Miller 2 series. Still pending.
What is that to show this is delivered, sir?
2, Annexure 2 Miller.
What is there to show it was delivered?
No, that the OP number 4 and 5 are forcibly possessed the government land, Miller.
Sir, please try and follow the question. Maybe you should ask him. He doesn't understand if I ask him.
What is the proof that you have served the representation before the authority? Any
My lord-
endorsement is there?
My lord, I have
Acknowledging your
not.
representation.
Page 13.
My lord, page 10, Miller. Page 10, Miller.
Sir, have you understood the question he asked you?
My lord.
Again, repeat. The fourth time we are asking you, sir.
Page 13.
There is no endorsement
arrow,
acknowledging
record of
your
rights, Miller.
representation.
That's
I
By the
received
authority.
already. I have filed, Miller. Received the original with me, Miller.
page 13.
Post Miller. Registered post, Miller. Original with me, Miller.
Make a fresh representation, sir. The all got lost now. Permitting the petitioner to make a fresh representation in accordance with law. So to the authorities, and after following up some representation, to seek appropriate remedies in accordance with law. The petition is disposed of. All right.
Supplementary item 42.
Item 42, my lord, this matter has been infructuous.
All right. Counsel the petitioner states the petition is rendered infructuous. It's disposed of as such.
Item 3.
My lord, here the farmers of the Balangir district, they have approached by way of this PIL with a prayer to direct the opposite parties to pay full compensation on the basis of the 100% crop loss in 2015. Your lordship kindly see the order dated 14/1/2020, where the some of the opposite party did not receive notice, again fresh requisites was filed, and thereafter the parties those have received notice earlier and subsequently none of them have the counter affidavit till today, and it's a detailed petition filed how in spite of the statutory committees recommending 100% loss of the crop, but because of the peculiar circumstance and at the behest of political persons in an illegal manner, they have been paid less than the premium they paid. This was the entire averments in the petition. And the state government and the central government scheme, which is adopted by the state government, they have not yet filed the counter affidavit. A short time may be given to them to file the detailed, elaborate counter affidavit. So
None
that
of the opposite parties seek to file an affidavit in reply to the petition.
Because the notice was issued.
The last opportunity is granted to each of the respondents to file the replies within 8 weeks, rejoined for the next day.
I am appearing for the opposite part number 3.
4 and 6.
19 notice has been issued, 2019.
5th January 2023.
3, 4 and 6.
Supplementary list item 44.
Your Lordship has fixed 5th of January, Lordship.
Item 44.
None appears this was no prosecution.
Supplementary item 45.
None appears this was no prosecution.
Supplementary list item 46.
46, my lord, if I may please your lordship, the matter is relating a panchayat fund, my lord. The counter has already been filed by the opposite parties, my lord, but I may be given a time to collect. It has been misplaced by our office. I'll just recollect.
No, what's the matter about? Tell us what the matter is.
It's the
about.
panchayat fund, lord.
You can go to the Lokayuk, sir. Please go to the Lokayuk for this. The present petition alleges misuse of panchayat funds by the Mauzuda Gram Panchayat Sarpanch, permitting the petitioner to approach the Lokayukta in accordance with law. The petition is disposed of.
Supplementary list item number 47.
My lord, item 47, my lord. My lord, there's a noting that I have filed my wakalat without taking consent from the previous counsel, your lordship. But I had received the prisoner's petition, my lord, wherein I was asked to enter appearance. Lord, that your lordship would find, my lord. I've annexed it to the wakalatnama.
Anyway, how long has your appellant been in jail? You are appearing for whom, sir?
48.
48. Don't stand up, sir. We are now in 47. I would presume you are appearing in 47 if you stand up.
My lord, for more than 9 years, circumstantial evidence case since 6/6/2013 in custody.
Since in 2006?
In 2013, your lordship. 6/6/2013. My lord, for more
13.
than 9 years. Yes, my lord.
9 years.
Not admitted. Not admitted. No, sir. Also can verify because my file says that has not been admitted.
Not admitted yet. Oh, I see. Admit LCRB requisition, paper book prepared within 8 weeks.
Would have filed an
I see notice of the application for bail. Fine be suspended. That do IAS.
My lord, one was
991 and 648. You say notice. Mr. Katke accepts notice and seeks time for instructions. September, sir.
27 September. Extremely grateful, your lordship.
Supplementary list item 48.
It is also not
admitted. Yeah. Same. Paper books be prepared within LCRB requisition. Paper books be prepared and supplied to counsel for the parties to be included in the final hearing. Similarly, in 49.
Item 49.
The fine that is state, admit, LCRB requisition, paper books be prepared, supplied to counsel for the parties. On the bail, how many years is he in bail? You're in 49. Who's in 49?
I am for the 49.
How long has he been in custody, sir?
Since during trial he was on bail, but from the date of judgment he is in custody.
Sir, please tell us the date, sir.
I don't have the copy. My land friend.
Custody since 18/7/22.
Then you don't press it. It's 302, right?
My lord.
So don't press at this stage. You said the bail application is not pressed at this stage. Disposed of. All right.
Item number 50.
50 minutes, I on behalf of Mr. Atke only kindly pass over my.
No, it's admitted, sir.
Instruction was that is for loss.
Stay of fine. The expected date of delivery is there, sir.
Yes, boss.
So yes, then 2022, a report has been received from the IIC Chendipada PS, dated 8 September 2022, that the wife of the appellant is in an advanced stage of pregnancy, and her expected date of delivery is 24th October 2022. In that view of the matter, it is directed that the applicant will be released on interim bail on 10th October 2022 for a period of 3 weeks, subject to terms to be fixed by the trial court. The surrender certificate be placed on record immediately upon the expiry of the interim bail period. The application is disposed of. All the others same. LCRB requisition and all that. The main application. Right.
Supplementary list fresh admission item 51.
Permitted 2 weeks time for filing of a rejoinder.
Rejoinder to be filed before the next date. List on 10th January.
Supplementary list fresh admission item 50. Item number 60.
None appears dismissal opposite.
Supplementary item 61.
Memos taken on record, no instruction, dismissed.
Item 62.
My lord. Item number
62
is a CMPL for restoration of rate petition which was dismissed by the learned ADA on 18.
What's the delay in filing the CMAPL? Let's see that.
Acha. The delay as is 77 days, but the order passed by the ADR on 13th December 2019.
99 days delay in the CMAPL itself, sir.
77 delay.
99 days delay in filing the CMAPL.
This is 62.
There's an unexplained delay of 99 days in filing the CMAPL itself. Consequently, the court is not inclined to condone the said delay is not properly explained. The court therefore dismisses miss case number 165/2021. Consequently, CMAPL 163 of 2020 is dismissed. Right.
Item 63.
Same. I think. What's the delay? Just see again here. 166. I think same. Same order. Only the numbers will change.
Right. Item 64.
May it please, my lord. This is an application to leave for leave to appeal against order of acquittal under section 302. My lord, I'll draw your lordship's kind attention to the manifest error in record and the recording by the learned trial court. That is at page 36. Only 2 paragraphs, your lordship will be convinced, 2 lines. Page 36 from the bottom, your lordship may see. It says, none of the witnesses have stated as to whether Paresh accompanied the accused person to such Mandali house and whether the deceased Paresh was all along with the accused person. Now, this is manifestly, my lord, wrong. In the sense, my lord, your lordship may see page 17, the evidence of the witness. They have all stated that the accused persons have accompanied the deceased throughout and in the...
All right. You say miss case number 18 of 2022, the delay is condoned. The application is allowed. In the main CRLP, you say notice returnable. He accepts notice on behalf of the state. Notice will issue now to the opposite party number. Sorry, respondent numbers 2 to 6. Returnable. 3rd January 2023.
Supplementary item 65.
My lord, may be permitted to withdraw with liberty to file a comprehensive application.
Counsel to the petitioner seeks leave to withdraw the present petition with liberty to file a comprehensive petition.
Sorry to disturb your lordship, my lord.
Withdrawn with liberty is paid for.
Sorry to disturb your lordship. Why not 64? One document inherently I have not filed. My lord, that
you can file it later, so no problem.
Yes, right.
Supplementary list item 66.
On behalf of Mr. What's kind of password?
All right, pass.
Item 67.
67, my lord, there has been a delay of 91 days and in filing this appeal.
What's the delay for? How have you explained it, sir?
My lord, because of his ailment and he could not come. And certificate has also been given.
First, IA number 2856 of 2022 is notice on this IA. Returnable 4th January.
Lordship, a little bit early, 4th January. Arbitration proceeding has. I
Okay, sir. You've taken 99 days to file. It's okay.
Because of the ailment, my lord, I agree. Lordship.
That's all right. That's all right. Yes.
Item 68.
Lord, I am told that the defect is with regard to not giving number of the learned advocates appearing along with me.
All right. What's the matter?
The petitioner here is challenging the order passed by the Honorable Single Judge, matter arising out of an OPLE proceeding. There is no dispute that the petitioner are representing a temple and the temple is standing over the government land. There's no dispute about that. Lord, I have only two things to say. One is, for my eviction, a 30 days period is prescribed under the mandatory requirement of the format rules, and for me to prefer an appeal, a 30 days period is there. Now you are giving me a notice to demolish and evict on 24/8, falling short of the required 30 days. On 4/9, you are giving me to demolish my building. Falling short of required 30 days, both 13 appeal and 30 days notice for demolition under Form B. Lord, I approached before the Honorable Single Judge. Honorable Single Judge has relegated me back to the appellate authority, but Lord, I am only agree if your Lordship would kindly turn to page 24. I must, before that, take your Lordship that I have already filed an appeal. I have already filed an appeal before the sub-collector. My appeal has been registered as 23 of 2022. But in view of the observation in para 8, my lord, that will create a problem and prejudice the mind of the...
All right. You say counsel for the appellant informs the court that the statute is filed before the appellate authority and is numbered as appeal number
23 of 2022.
23 of 2022. Full stop. Nevertheless, it is apprehended that in view of the observation in para 8 of the impugned order, the appellate authority may not be inclined to grant any interim relief pending the disposal of the appeal. Paragraph, it is clarified that the observation in para 8 of the impugned order will not come in the way of the appellate authority considering the application for interim relief in accordance with law.
That's it. Grateful.
The appeal is disposed of.
List item 69.
May I please, Your Lordship? Interim bail application last occasion, my Lawrence.
Yes, sir. I have received the instruction.
That's right. Last time
Last
you
two
mentioned a
lines.
wrong.
Yes, sir.
Yeah.
She was ill in the month of June. She was treated in the district.
Again, same thing, sir. She's not attending. She is declining to go to DHH Raigada or SLNMCH Koraput.
Due to Your Lordship, non-ability of male as well as the financial condition of Your Lordship, she is unable to went to the hospital for better treatment, Your Lordship, for which I seek for interim bail for some period so that he will.
So this report should say if there's male member or not. It doesn't say that. That's the main ground. He's even last time said that there's no male member to accompany her. That's why she's not going.
So that part is not there.
You say it is acknowledged in the report submitted by the IIC Raigada PS. The petitioner's wife, the applicant's wife, is indeed suffering from an ailment for which she needs to conduct an USG of the abdomen oblique pelvis. Counsel to the applicant states that she is unable to do so because there is no male member to accompany her, of the family to accompany her. In the circumstances, directed that the appellant be released on interim bail for a period of 3 weeks, beginning the date of his actual release, subject to the terms to be fixed by the trial court. The surrender certificate be placed on record after the expiry of the interim bail period. The application is disposed of.
A lordship granted.
Item note
Obliged.
70.
1 week time may be granted for removal of defect.
Taken some 3 bail orders. Can't, it has to be signed in time.
1 week time may be granted for removal of a defect.
Defects be removed within a week list there. So you have to immediately go and get them. This there. Defects be removed within a week list there. This is for admission, is it, or it already admitted?
Not admitted.
Not admitted.
We admit it, sir. Best is to do that. You see, admit the LCR be requisitioned. The paper books be prepared and supplied to counsel of the parties. List in the final hearing list. In the meanwhile, defects be removed. Same for 71,
71,
72,
72,
73, all same orders. Defects
May I
be
please,
removed.
Your Lordship?
We're admitting all of this.
Item 72. On behalf of Mr. R.K. Patnaik.
Admitted, sir. It's already admitted.
Obliged.
Supplementary item 74.
74, my lord, your lordship permitted to withdraw with the liberty to file if any cause of action survive in the meantime.
Petitioner seeks leave to withdraw the petition with liberty to file a fresh petition when any cause of action survives. The first type of the bail order.
Obliged, my lord.
Supplementary list for hearing item 75.
May I please? 75, my lord. The earlier occasion imbue issued against the appellant. There are 3 appellants, my lord. I am instructed that one of the appellant of 3 has already been arrested. So for appellant 1 and 2 is concerned, my lord. Though nobody there in their family, my lord. There are all 3, father and 2 sons, my lord. After the occurrence, they left that place and resided at Sambalpur, my lord. And I want also some instruction, my lord. Any date next week hearing?
No, you argue the matter, sir.
Or they both, whether they have been arrested or not,
that's okay. Anyway, meanwhile, you argue the appeal.
My lord, I am ready to argue the appeal, but in fact, my lord, I want some, since I am a newly engaged counsel in this case.
Not newly, sir. You
in this case,
last time.
Last associate there, my lord.
No.
But in fact, since she is unable, my associate unable to say whether they are available at a Kotak or native
whatever,
place.
sir. As far as the appeal is concerned, being
but the appeal is concerned, my lord. All total 5 accused persons faced their trial, my lord. During midst of the trial, one of the accused expired, my lord. And 4 persons, my lord, faced the trial. And one Sagar Mahapadra has been acquitted from the charges level against him due to inadequate evidence, my lord.
Right.
So for this case, present case is concerned, my lord, there are 2 eyewitnesses to the occurrence, my lord. Schedule 11 and 14, my lord.
Yes.
That apart, my lord. So far the case is concerned, my lord, there is no, absolutely there is no independent witness, my lord, though the place of occurrence is a public road, my lord. No independent witness examined this case, my lord.
All right.
And that apart, my lord, there are 2 FIRs, my lord.
Yes.
From the side of the deceased persons, one FIR that is PS case number, Baden PS case number 49/2020. So far from the side of the appellants, my lord, Baden PS case number 50/2020. Same day both the cases are arrested, my lord. And so far the present case is concerned, there are 2 parts of the occurrence, my lord. On the previous day, occurrence taken place on 20th 8 2000, my lord.
Yes.
But 19th 8 2000, August 2000, my lord, there was a quarrel between 2 ladies, my lord. And one of the accused came to the occurrence and threatened that lady and abused her in filthy language. On the next day, it is already one of the deceased while going to his field in order to for watering his field, my lord. By the time there, and he challenged the disease. Why in the previous night you demanded money? For that reason, he assaulted by means of a spade, Kudi. And thereafter, it is alleged that two of the appellants and other two appellants came to this spot, being armed with Gupti and other Gupti and Bhujalip. And thereafter, other two appellants also came to this. Two accused persons, co-accused persons came to this spot. It is alleged that all the acquitted accused, who has been acquitted, my lord, he caught hold of the one of the deceased. 14th evidence is concerned. Caught hold of one of the accused, and accordingly, all three appellants assaulted two of the deceased persons mercilessly. That is the allegation, my lord. So, for my humble submission before Lordship, my lord, since, my lord, the police, neither from the side of the prosecution, nobody informed the police, my lord. Police got a telephonic message from a reliable sources, came to the spot. By the time no persons are there, at the police simply found two dead body, my lord, at this spot. All the family members present at this spot. Thereafter, the informant came forward and lodged the information before the police at this spot. That is the allegation, my lord. So far, my lord, it is for better apprehension, my lord, I may be permitted to place the judgment first, my lord.
Yes.
Paragraph 2. The prosecution case, since a double murder case, I want to some time, my lord, so that no time, but I will argue this case today. Also, another date may be so that I am able to.
All right. Which of the three are? Which one has surrendered?
My lord, my instruction that, my lord, the appellant number 1.
What are your instructions, Mr. Katia?
Surrendered. They absconded. Probably last week they have been arrested.
And one arrested, two surrendered. That is my.
One person is there. Is he here?
One person.
No. Who has been brought to the court? There's somebody standing there.
No. Some in another case, my lord. Not the present case.
Which one of the three has surrendered?
Not the Rajkushan Mahapatra, my lord. The appellant number.
Rajendra Mahapatra.
Rajendra Mahapatra arrested, my lord.
Or it appears that
and other
appellant
two, my
number 2 has been arrested, but appellants 1 and 3 are stated to be somewhere in Sambalpur. Where is the address?
Sambalpur, they have surrendered, but I think they have surrendered before.
My instructions, they have been arrested. I'm just taking
all right. The report of their arrest be placed before the court on the next date. Mr. Ragada needs some more time to prepare his arguments. At his request, list on 12th October.
My lord.
All right.
Item 26. May I please?
Yes.
My lord, I am appointed to the legal service authority, my lord.
Right.
My lord, the appellants have been convicted under section 302, reduction 201 and 34 of the Indian Penal Code, and an imprisonment for life. Out of the 3 appellants, 2 have already been died, my lord. One appellant 1 and appellant number 3.
Have this court already noted it?
My lord.
All right.
2. The only 2 is survived. My lord, the
Sukalu Bhunia.
My lord, Sukalu.
Right.
Sukalu Bhunia. In total, 10 witnesses have already been examined. The entire case is based on circumstantial evidence. And basing on the medical evidence and lasting theory and recovery of weapon of offense, the conviction is made, my lord. My lord, the lasting theory, the PW8, my lord, is the son of the deceased, aged about 9 years old. In his cross-examination, my lord, he had stated that the accused person, namely Chandra and Sukalu, also went to the PS. Sorry. In the cross-examination, he stated that Sukalu's wife went to bring a rope, and seeing this, I ran to the village. I did not see anything thereafter. My lord, last inquiry based on his statement, my lord. And my lord, there is the statement of the witness have not been corroborated regarding the weapon of offense seized. The stone seized by the police and the witnesses to the seizure are PW5 and PW6. PW5 stated that PW5, the headman of the village, he stated in his cross examination that the stone which is seized by the police was blunt. And the police pressurized the accused, appellant number 3, Guru Bhaiya. And thereafter, the accused led the police and others to the spot where the dead body was concealed and the weapon of offense used. And my lord, the wife of the deceased also in her cross-examination stated that the accused, namely Chandra Sukalu, also went to the PS. The present appellant also went with the village head and the informant to the PS. There in the outpost, he was detained for 3 days. And after registration of the case, the police detained those 2 accused persons in the PS and did not leave them. My house is visible from the house of the Sukalu. I did not ask anything to the wife of the Sukalu immediately after the. My son came and reported me that on the Sukalu's wife going to search for a rope, he fled away from the spot. So, my lord, the weapon of the rope that was used, whether it, that there is doubtful that as the witness was seen lastly, his strategy differing in cross-examination or in chief examination, then hence the rope that was used is doubtful, my lord. And my lord, the most important thing is that before reaching the police at the spot, the dead body was already been shifted by the villagers. That, my lord.
1 o'clock, is it? We'll continue after lunch.
Thank you. Also, item number 1.
May I please, Your Lordship? That the appellant charged under section 302, 376 2F, 209 IPC, and section 4 of POSCO Act. My lord, I am pressing for bail, my lord. IR number 361/22. My lord, the
Who is appearing for the state?
My lord, it's no noting for us, my lord. My lord, Your Lordship, give me half a minute, my lord. This fine.
How long have you been in, sir?
nine and a half months, 9 years above, my lord.
9.5 months, but this is a killing of a 10 years minor, sir.
Yes, ma'am. Yes, ma'am. Because so far the case is based on circumstantial evidence as well as no eyewitness, my lord.
Absolutely, but leading to recovery, confession before police, all these things. Of course, 9.5 years, we can't hear the matter now.
That's right. That's the only problem.
My lord, because, my lord, as per the confession regarding the police, the section 25 and section 26 reflects the magistrate should be present, my lord. Here the magistrate is not the present before
No, let us criminal antecedents.
Para 21 at the top, present case is based on circumstantial evidence only.
Right, right. Are there criminal antecedents?
The deposition copies are also not with us, my lord. They have not served a deposition copy, my lord. And it shows that enough materials are there against this, my lord. Extrajudicial confession is there, leading to discovery is there, my lord.
No. But he's been in for 9.5 years. And there's no prospect of the appeal being taken up in the immediate future.
Yes, my lord. In that case, Your Lordship may grant a short date to find out the antecedent, my lord.
Friday, sir, we'll take it on Friday. Or?
My lord, may I Monday, my lord.
Monday?
My lord.
Well, we can't sit as a special bench on Mondays.
On Friday, my lord.
Friday.
On a Friday, my lord.
List on Friday.
My lord, in the meantime, can I pray that deposition copies may be given, my lord?
Oh, Friday is tomorrow, right? Can it be next Friday?
Yes, my lord.
Let it be next Friday. Next Friday.
14th, my lord.
16th.
Sorry, 16th, my lord. 16th.
List on 16th to enable the State Council to take instructions for it.
Deeply obliged, my lord. Deeply obliged.
My lord. The entire case based on circumstantial evidence. And basing on medical evidence and the lasting theory and the recovery of a weapon of offense.
Mic is working or not?
The medical evidence, basing on medical evidence and the lasting theory and the recovery of a weapon of offense. My lord. My lord, with regards to lasting theory, the disease was initially seen at the morning at about 5 to 7 p.m. a.m. and the dead body was last recovered at the evening. There is a time gap of about 10 to 12 hours. And it should be, the time gap should be so minimal so as to arrive at a conclusion that the present appellant is the author of the crime. And there is possibility of the benefit should be done in favor of the present appellant. As because there is a gap of 10 to 12 hours of time. And my lord, the recovery of weapon of offense. PW 5 stated that the weapon of offense was seized that by the police. That was not this. I am placing the cross-examination part of the PW 5. I am the headman of the village. In the village panchayat, the accused Sukalu did not confess to have killed the deceased, but stated that on account of the land dispute between the deceased, and then they had tied the hands of the deceased and taken him to the Temurghat jungle. The police were not present in the meeting. The stone which was seized by the police was not bloodstained. The informant came and told me that the deceased was tied by the son of the deceased did not tell me anything regarding the incident, nor he was present. There is a past enmity between the deceased and the accused persons. We searched the dead body but could not find it. Thereafter, we reported the matter to the PS. The police came and joined us in search of the operation, and accused Sukalu showed the place where the dead body was concealed. The police pressurized the accused, and thereafter the accused led the police and others to the spot where the dead body was concealed. And it is being pressurized by the police. My lord. And my lord, even though the affair was lodged on 6/3/5, and the appellant was voluntarily accompanied the informant and the village punch to the police station, detained at the police station on 6th. But it was the recovery was made on 8th. And why the police have detained 2 days and not made in the recovery of the weapon of offense, then my lord, it is doubtful. And my lord, before inquest, the dead body was shifted from its original place to another place. And the IO stated that there was also other ropes. 2 other ropes were also tied with the dead body, my lord, including the ropes tied in his hands and the legs of the deceased, my lord. And most importantly, the witness PW8 has stated that he has not seen that the appellants have tied the legs and ropes of the appellant in his cross-examination.
Yes,
my lord. Hence, it should be doubtful that the present appellants will be the author of the crime.
Yes, Mr. Ms. Patnaik. Yes.
May I please, Your Lordship?
Yes.
My Lord, PW2 is a doctor, my Lord.
Yes.
At page 46.
Death is homicidal.
My Lord, at page 46 is the deposition of the doctor, my Lord.
Correct.
The doctor, Your Lordship, said there are 4 injuries.
Right.
Injury number 2 is the injury on the head. That is by means of a stone, with the medical opinion corroborates that, my Lord. And the 4th is a ligature mark present over the wrist and ankle joint of both foot. But from here, I'll take Your Lordship to the deposition of the son. He is the person who has last seen his father in the company of the accused persons, to the extent that he has seen that the accused persons have tied his hands and legs, seeing which is a boy of 9 years, my Lord, is a minor. Seeing this, he runs and informs this to his mother. And after the mother and the son, they have come back to the jungle, they don't find the dead body. After which they have gone and gone to the sarpanch, person to which a punch has been called for, in which in the night, in front of the house of one of the co-accused, in which 2 of the co-accused have confessed that yes, due to land dispute, we have done this. Here, my Lord, I'll take Your Lordship to deposition of 2, my Lord. It's a very small deposition of the son. I and my father had gone at page 57, my Lord, of the paper. Should I read, my Lord?
Yes, please.
I and my father had gone to the nearby forest to collect mohola on Saturday early in the morning. On seeing the accused persons who were standing in the dock on that day, my father asked them as to why did they set fire to the haystack. At that point of time, accused Sakula Bhumia tied the hand and legs of my father by means of rope. Seeing this, I ran to my house out of fear and reported the incident to my mother. And thereafter, my mother and myself rushed back to the spot and found my father missing. Then the matter was reported to our villagers. After tying my father with rope, the other 2 accused persons pulled him to the forest. Cross-examination, Sukula's wife went to bring a rope. Seeing this, I ran to the village. I did not see anything thereafter. But there is medical evidence to show that there were hands and wrists were tied with, there were ligature marks behind the hand, in the hands and the legs. Then PW9 is the wife, my Lord. She also states the same. My Lord, the deceased is my husband. I know the accused person standing in the dock. The occurrence took place more it was Saturday. My deceased husband and my son Hari had gone to the nearby forest to collect mohola. My son came back running to our house and reported that while he and his father were plucking mohola, they came across the accused persons, and on seeing them, my deceased husband asked why they set fire to his haystack. And hearing this, the accused persons overpowered my husband, assaulted, and thereafter they pulled my husband towards the jungle. Immediately after getting the news, I, along with my son, rushed to the spot and found my husband missing. Thereafter, returned to my village and reported the matter to the village Sarpanch Hari Naik and village Peda Maji. Immediately, the village panchayat was convened and accused Chandra and Sukala attended the same. And on being questioned by the villagers, they admitted to have killed my husband in the forest. Thereafter, accompanied by some persons from the panchayat, I went to the nearby police station and reported. So, my lord, there was a motive, there's a last sin theory, and again, there's an extrajudicial confession before the punch. And leading to discovery by one of the accused persons, not Chandra, but this accused person has led to the stone, which was behind a bush, and the IO says that it was not visible to the naked eye. It was they have recovered it at the instance of the accused persons. Now coming to the my lord. The stone was stained with blood. that is the finding of the learned court below also. That was fine one, it was B positive. But I should fairly concede, my lord, that after that I don't have the forensic report with me. The forwarding report is there, but learned court below has said that human blood was found and blood group was B group. That was found from that. If you can take to your lordships, I'll just read it out, my lord. It is seen from the record that the stone place was sent for chemical examination. I'm reading from the judgment, my lord. Page 20. Page 20 of the. It is also seen from the record that the stone piece was sent for chemical examination to RFSL Barampur, and chemical examination report states that the stone piece is stained with blood of human origin and grouping of blood is B. Therefore, the death is homicidal. That is what it's saying. So, my lord, my humble submission is that this is a clear-cut case of homicide which has been seen, a part occurrence has been seen by the son, whose credibility could not be shaken through cross-examination. The wife also states about the motive. There is a clear-cut motive regarding land dispute, which all of them have stated, even the Sarpanch and the other villager also, co-villager, they have also supported. And the medical opinion regarding the stone is also a positive, my lord. The doctor very clearly says that the fracture found on the face and the head of the is possible by this stone, my lord. And bloodstain was found on the stone, and there is an extrajudicial confession before the punch. So these are the 5 incriminating materials that definitely goes to show that these people are the author of the crime.
Right.
My last submission is the appellant number 1 is the person who was leading to discovery was done by him. And my lord, mostly the persons are tribal persons, and they have no motive.
One more thing, my lord. My lord, appellant number 3 is dead.
Yes, we've noted earlier.
1, 3 both. 1 and 3 both.
1 and 2 are on bail.
All right. Orders reserved.
Past door matter item number 37.
My pleasure, Lordship. Lord, the matter is consist of violation of national river policies, because it is about the river Brahmani, which is in stake. In nutshell, before going to the petition, Lord, Brahmani is constructed at Bedabas, Panpos, Odisha, district of Sundargarh, near Rourkela, and 2 rivers, Shankha and Koili, regenerated from Jharkhand. They have united there and born the new river Brahmani, which is the second largest river of Odisha, and basic lifeline of Odisha, mostly depend upon them. And here, Bedabas is a spot where Vyasa has written Mahabharata. There is a cave below the base of the hill. There is a Shiva temple, and on that point, it is also a holy place. So here, my submission before your lordship is that both the rivers, Shankha and Koil, as it is generated from Jharkhand state government is making barrages over both the rivers, which is reducing the flow of water resource to the newly born Brahmani river. On the basis of Brahmani river, 6 districts of Odisha are passing through, and out of which that Nalco and the Rourkela steel plant, all these plants are also constructed basing upon that Brahmani river. Also, the world's one of the biggest ecological park, Bhitarkanika Park, is also based on the Brahmani river, and also that park is getting water from animals and plants, and all the river Rengali Dam and other dams are also made for construction of irrigation and electric power generation in Odisha, which are coming to the stake due to the undue illegal construction of barrages and dams by district state government of
sweeping
Jharkhand.
prayer, madam.
Pardon?
Look at the prayer clause. It's such a broad sweeping prayer.
Let the humble
Just see
submission
the
of the,
second prayer in your prayer clause.
and also this honorable court may kindly be pleased to consider the hardship which may cause due to the construction of dams and barrages over the river Sankha and Koel and supporting the river of Brahman by the government of Jharkhand and the stake of the life and livelihood of the people and animal as a whole of the corridor of area. So these dams and barrages which was constructed by Jharkhand government was not consulted with national authority or the state authority of Odisha. They, up to what extent of water and dams and barrages would control by them, and about minimum what water amount should be.
All this has to be taken to a river water dispute tribunal.
Pardon?
This has to be taken to a different expert body. It's not supposed to be dealt with by the High Court in a PIL. There are interstate river disputes tribunals that have been set up. So it has to be dealt with at a different level, madam. It can't be dealt with in a PIL and a writ petition.
They have
These are highly complicated questions. It can't be dealt with like this in a PIL.
This honorable court may ask the state council to bring their expert reports on these matters.
We have no expertise, madam. We are in no position to decide how much water should be released, how much water can be kept in a dam. These are not matters which two High Court judges can decide.
Milord, my humble submission before your lordship, sir, this honorable court may direct to those authorities. They will come with their papers and submit before your lordships, which your lordships can explain and come to an conclusion.
We cannot explain, madam. We don't. I don't know about Justice Dash. I am totally illiterate on these things.
Milord,
you may be very knowledgeable, but I am not knowledgeable.
Milord, they will submit their documents.
I know. I don't even know how to read those documents, madam. It'll be very difficult for me to read it. It will talk about so many cusecs, so many release of so much water, so much inflow into the dams.
Milord, my humble submission before lordship that could have been shared from the beginning.
Correct.
So that it could have come to that water tribunal.
Correct.
But unfortunately, those long time has been passed.
Correct.
And we are suffering. And now this honorable court says that about the expeditions report that can be called for and that can be adjudicated.
We cannot. Therefore, if you've seen the interstate water disputes tribunals, they go on for years on end. I'm sure you watched those proceedings. They come with huge expert bodies on both sides and thousands of pages of reports. Evidence is actually laid on those reports.
These counters have already been basing upon their counter and rejoinder and date chat. Your lordships may kindly dispose of the matter at this end, Milord.
We'll pass a longish order. All right. We'll pass it's disposed of. I'll pass a detailed order. All right.
Pastor matter item 66.
Made things. My lord, here actually the case has been dealt with finally by the High Court in both the single judge also, but only one annexure has been left. Annexure 11 has not touched. Annexure 11 is a circular from their own department as to how punishment has to be imposed. While imposing punishment, what should be the consideration? May I take your lordship to Annexure 11, page 131? It started with page 131 and said, I am concerned with at page 140, my lord, that is 67H. If the otherwise the case has been gone into a disproportionate punishment, no case has been made out in that. I am not challenging it, but it is their own circular. They have to be abided by this. Since this circular has come subsequently, they have not considered it. Neither the court has directed them to consider. Therefore, I seek only a direction to the authorities to consider about the circular, whether 67H can be invoked in the case.
What is the order of removal or dismissal? What is the order?
Dismissal, my lord.
Just come to the impugned order.
Pardon, my lord.
If you come to the order passed by the learned single judge,
My lord. My lord.
there are as many as 8 charges, sir.
Pardon, my lord.
Understand anything I say.
There are as many as 8 charges.
My lord.
Ah.
Therefore, my lord, I am not there on the charges.
No. Given the number of charges that have been proved, partly proved,
My lord.
why is the punishment disproportionate? That is what you have to tell us.
I am not entering into the disproportionality of the punishment, my lord. That has been gone into by the single judge, my lord. I am there only on the applicability of Annexure 11, my lord. It is their own circular.
No, for what? Applicability for what, sir?
Applicability for, my lord. May I take your lordship to page 140, my lord? Page 140.
No. What do you want them to do, sir? After applying the circular, what do you want them to do?
They have to consider whether this punishment can be brought down to.
So you are on proportionality, sir.
So therefore, to be imposed on officers, this punishment is to be imposed on officers where officers have completed 20 years of pensionable service and attained the age of 50 years. My lord, I have rendered already 34 years of service.
No, but with 11 charges, many of them proved.
Let them consider it their way, my lord, if they can. I am not invoking the judicial entry into this matter only because of the fact that this circular has come subsequently.
You see, the
otherwise, all other points have been gone into by the single judge. I am not challenging those decisions.
The challenge the present writ appeal is to an order dated 16th March 2021, passed by the learned single judge, dismissing the appellant's writ petition civil 966 of 2009, whereby the appellant had questioned the findings of the inquiry officer, bracket EO, the decision of the disciplinary authority, bracket DA, and the consequential order of the appellate authority, bracket AA, confirming the order passed by the DA dismissing the appellant from service. Paragraph. It is seen that 8 broad articles of charge. 11, sorry. 11 articles of charge, of which 3 were held not proved, 3 were partly proved, and the remaining were proved.
One charge has been proved taking advantage of their own wrong manner. They have not released my salary, therefore I have exceeded the amount of loan taken from them. That is ground number 8 revealed at page 8, my lord.
All right.
For the inquiry report and the respondents have not taken
judge has not been persuaded that any legal infirmity vitiated the disciplinary inquiry and the orders passed by the DA and AA. Paragraph. Learned counsel for the appellant submitted that he is pressing for the present appeal only insofar as he requires the opposite party, the respondent bank, to consider the purport of a circular issued by it on
May 10, 2016.
Which page is that?
Page 131, madam. 10th May 2016, and it was made a part of the agenda.
231. 131.
131, man.
131 is a reply affidavit.
One 131 to page 141, that is the circular. Annexure 11.
There's no annexure 11. This is joined, is it? No annexure 11.
May I hand over my brief, my lord?
On circular dated 10th May 2016 concerning effective interpretation of punishments in disciplinary proceedings. Of the respondent bank. So in particular, submits that since the appellant has already put in more than 30 years of service.
34 years.
Nearly 34 years of service. That should be kept in view while awarding a punishment. Paragraph, the court notices that in the present case, there were 11 articles of charge, and barring 3 of them, the remaining were either proved or partly proved. So, given the nature of the charges, it is not the court is not persuaded that the respondent SBI should be asked to apply the above circular for the mitigation of the petitioner's punishment, appellant's punishment, since some of the articles of charge of which he has been found guilty are of a grave nature, touching on the integrity of the appellant. Consequently, the court is not persuaded to require SBI to consider the applicability of the aforementioned circular in order to mitigate the punishment. No ground is made out for interference. The appeal is dismissed.
For hearing item 77.
Lordship, item 77, today morning I got information that one of the accused, namely Kasinath Kaitan, has died. At the meantime, Lordship. Lordship, kindly take it up next week.
Why? You can argue as far as the remaining are concerned.
Yes, Lordship, I am not prepared well, Lordship. That's why.
No. Which appellant? There's only one appellant in this case.
No, Lordship. CRL 417 of 2008, Lordship. Kasinath Kaitan.
So that is abated. In criminal appeal 417 of 2008, you say counsel for the appellant states that the appellant has expired. When?
I have not received the date, Lordship. Today morning.
That doesn't matter. The appeal is disposed of as having abated. In criminal appeal 455, you say at the request of counsel for the appellant. List on 19th October.
Item 7.
Please, my lord, I'm here on behalf of Mr. Devashish Panda, my lords. He's in set. Pray for his accommodation.
He's in well,
for the respondent. It's a government
after case, actually, I was appearing for the informant. It was adjourned.
Which one?
The previous,
the other one.
Item 77.
Oh, I see. All right. You say in 78, Mr. Panda, Learned Counsel appearing for the
78, my lords. I'm for the informant. They want an adjournment here. let them take an adjournment, my lord. From the informant side, I just want to submit that if the hard copies of the paper book can be called for, we have tried to collect the soft version by using a pen drive. There are some colored photographs which may be necessary.
Paper book must be here.
The LCR.
LCR. Oh.
There are, because the deceased died in the bedroom of the accused. So there are some photographs which are in black and white in the LCR, in the digitized version. So the colored photographs would throw some more light regarding that scene of occurrence. So it's very difficult to get it from the local court for us.
I know.
So if that can be called for.
Okay. Wait, which is this court?
This is, my lord, from Cuttack.
Oh, Cuttack. All right.
Fast track.
Mr. Gautam Mishral and senior counsel appearing for the informant states that the original TCR contains some color photographs and therefore it should be requisitioned. The original TCR be requisitioned from the district court Cuttack for the next date, 19th October.
It was tried by the additional session judge, fast track court Cuttack. So,
right.
Now sessions court would have.
Right.
Your Lordship is posting it 19th of October.
Yes.
19th September.
19th October, sir.
Oh, it's yeah, it will continue as far as 2, 3, 4 are concerned. You should say and others, no? The cost of it. Very misleading. Don't put others.
Supplementary list item 79. Item number 80.
My lord, pardon. My lord, I am submitting.
Yes, please.
My lord, here the appeal arise out of the judgment and order dated 4/11/2010 passed by the second additional session judge Cuttack in ST case number 305 of 2009 arising out of so and so GR case in Vidheshwar PS case number 11/2009, where the petitioner is convicted under section 30 IPC, which sentence will undergo rigorous imprisonment for life with a fine up to 20,000 paid, undergo RI for 6 months. Conviction is based on circumstantial evidence on the, such as orally dying declaration of the deceased made before PW1 and the opinion of doctor is the postmortem exhibit 4, chemical examination report exhibit 5, non-explanation of circumstance by the accused. Cause of prosecution: one affair was lodged by Kedu Pradhan, PW1, who happens to be father of the deceased, namely Akash Pradhan, aged about 8 years, alleging there is that on dated 22/3/2009, while the deceased was playing with the other children on the village road. At that time, the accused appellant called the deceased to his house and administered poison to him by mixing
chuda bhaja, for which the deceased died. During investigation, it reveals that while the condition of the deceased deteriorated, some villain called to the informant, that is father of the deceased, on inquiry about the reason the deceased disclosed before his father, saying that the accused forcefully administered poison by mixing rice powder. Therefore, the
Just
informant
ask them to sit down. Last benches. Let them not stand. All of them, ask them to all to sit down. Some lawyers can make way, please.
Some lawyers can come to the front or this side.
Yes.
Pardon. Thereafter, the informant carried the deceased by rickshaw, being accompanied with the Bela Pradhan, PW3, to the Kolapathar hospital. The doctor at the said hospital found the patient serious and referred to Bhubaneswar hospital. But while on the way to the hospital, the deceased died. The doctor at Bhubaneswar declared him dead. Thereafter, a affair was lodged after bringing the dead body to his village. Inquest was made by IO and post-mortem examination was made where bite mark was found over the internal wall, but the opinion about the cause of death was reserved with Exhibit 4, and viscera was sent to the chemical analysis. Exhibit 5 is the CE report, which reveals existence of organ phosphorus anti-cipidal poison. That the defense case is the defense of this accused is a denial of the occurrence and false accusation out of a previous enmity. Akash died due to snake bite. He had gone to field, and when he found the deceased in a critical condition and was about to die, he gave water to the deceased and brought him to his house and called his father and accompanied with his father to medical. The cause of conviction, the Lord and Second Additional Session Judge Cutoff convicted the appellant relying on the circumstance evidence basing upon alleged oral dying declaration of the deceased before PW 125, except and expert opinion of Dr. PW 7 and chemical examination report of the viscera Exhibit 5. Lord, my argument is the appellant that alleged oral dying declaration is not proved in accordance with law. The testimony of the witness suffer from material discrepancy, and no siege is made as to wearing appeals of this disease. No doctor has been examined. Disease to hospital at Bhubaneswar is examined. Previous enmity of PW1 with the accused is admitted by the PW1. With the accused is admittedly by the said PW1. With the cause is admitted by the PW1. With the accused is admitted by the said PW1. So false prosecution cannot be ruled out. Dr. PW7 found bite mark over anterior abdominal wall. It is relied that the death of the deceased for any natural disease cannot be ruled out. 7. No such alleged food whether chuda gunda, grind rice powder or semi-feed rice was found from the stomach of the deceased during postmortem. Rather, semi-digest rice was found from the stomachs. I do not see any incremental poison of rice powder from the prosecution of the accused or from the place of the alleged occurrence. That IO submitted that there is no other clue from his investigation to say that the accused is the author of the crime, except that fact that the witness stated to him that the accused had given poison mixed with the fried rice to the deceased. No spot map is prepared during investigation to ascertain the spot of this alleged occurrence. My lord. Conduct of PW1 to PW5 are doubtful. It is believed that they could know that the accused had admitted poison to the deceased before arrival of his father. Why they have not reported to his father? It appears from the statement of PWT2 that he was in the house and had scream of the witness Bela Pradhan, PW3. PW3 stated that the accused called the children and kept the deceased from half an hour and left him at the house of the informant when he was trembling and murmuring that the accused administered him poison. The same is not corroborated by any other witness, nor police stated about the same. There is no material proof that the deceased was sent to the Kolapatra hospital or Bhubaneswar hospital, but no name is of the hospital dictated by the IO. Chemical examination report is doubtful. It is stated by the PW7 that he had not kept the viscera in the viscera room, but it was kept by the sweeper, and the key of the viscera room was with him. Nothing is proved so as to whether the viscera of this disease was sent to the chemical examination. No motive is proved in this case. Benefit of doubt should have been given in favor of the accused. The prosecution has completely failed to prove any material to show that the accused had administered any poison to the deceased. Chain of evidence is not complete to convict. The conviction is unjustified, since none of the chain circumstance stated above the proof by the prosecution beyond the reasonable doubt is entitled. My lord, I may permitted to.
No need, sir. Your note is comprehensive. No need to read everything. Who's for the state?
For the state. Well, I'll take a time to answer, my lord. I'll answer tomorrow, my lord.
This is quite straightforward, madam. Just one oral dying declaration.
I thought the tales, we had not collected the paper book. So I was under the impression, but the paper book was in one of the other criminal appeal, my lord.
So it will go to next week then.
Monday, my lord?
All right. On Monday.
Item 81.
All these are date fixed, is it?
Personal appearance of the appellant.
These are all date fixed.
Mansingh.
Specific.
81.
Mr. Barik is the counsel for the.
Mr. Appellant is appearing in person.
Sorry?
Appellant is
all
appearing.
right. The appellant is present in person. He did not be present on the next date. Where is Mr. Barik? Give a call. He's appearing for the word sealers.
Item 81, JCRL 8 of 2011.
You have to phone up and ask Mr. Barik to come. He's in custody or he's on bail? Must be on
My lord,
bail. No?
he's on bail.
He's on
He's on
bail.
bail.
Ah. In that case, we'll list it in the final hearing.
Right.
Including the list of final hearing matters. Mr. Barik is not present. The secretary head OHC LSC will ensure that Mr. Barik is present whenever the appeal is taken up. Assignment. Yeah. The copy of this order be sent to the secretary OHC LSC.
Item number 82. Item number 82.
82. My lord, I am appearing for the appellant, my lord.
He's
There is a
he's in custody. He has been released on furlough.
That's what I thought. Then we fix a date. Right. And don't say list in final hearing. List on 21st November. 21st November, you tell him that.
Months.
He need not come again the next
Yes,
day. The appellant need not be present on the next day.
82.
82. I am appearing for the appellant. There is a direction for appearance of the.
All right. The appellant is present. Is he on jail or is he in jail or he's on bail?
Man.
Ask him.
He's in jail. He's still in custody or in bail?
Custody, my lord.
Custody.
Since 13 years, 12 years, 8 months.
Why is he being asked to produce?
Person lots of direction.
No. If he's in custody, we never ask him to produce. We never ask people in custody to be produced.
Of course, only with an impression that he's on bail might have been passed.
This is 82, no?
Right.
Where is the direction? How is he in custody? He was on bail and therefore we asked him to remain present. I'm not able to understand. He was released on bail.
Custody.
Police is in custody, Milos. Now he has been placed in Biju Patnaik open air ashram, open air jail.
Oh. Yes, continue.
The petitioner challenging the order dated 12th January 2011 passed by the London Assistant Session Judge Fast Track Court Bhavan Patana, convicting the appellant under section 302 of IPC and sentencing him to undergo imprisonment for life and to pay a fine of ₹5,000 and in default to undergo RI for 2 years. The prosecution is that on 13/10/2009, page 4 of the paper book, my lord, paragraph 2, a report was lodged before IIC Narla PS to the effect that on 13th October 2009, on a Tuesday during morning hour, the informant went and brought kerosene oil from the dealer. His son, it is a case of matricide, my lord. His son, the accused, went for the work to the Munigoda road and returned around 10 a.m., for which the informant went to work in place of the accused. Around 12 p.m., the informant came to his house and took his food. The accused was sleeping in the house and the wife of the informant, the deceased, was cleaning the rice. After taking food, the informant went to do the road work. Around 4 p.m., the brother of the informant
Arakita Gowda went and informed him that the accused was abusing his mother, the deceased, and also assaulting her. The informant rushed to his village immediately. Chintamani Naik, Suresh Masji, and others went to the informant, and they found that the wife of the informant was lying dead inside the room, having injury on the head. Hand and an axe was lying on the doorstep, having blood stain. Suresh Maji, Rajiv Maji, Dhaneshwara Chandra, and Sadhu Jal went and brought the accused from the village end, and being asked, the accused confessed that he killed his mother by assaulting by means of the tangia. On the basis of this report, the case was registered. The prosecution, my lord, examined 10 witnesses, and the defense, none of the witnesses was examined.
So there are eyewitnesses?
No, ma'am. This is basing upon the circumstantial witness. No eyewitness, my lord. The case was basing upon the circumstantial evidence. The scriber or
Extrajudicial confession.
extrajudicial confession or the extrajudicial consent should be voluntary, my lord. Here is not voluntary. They tied up the accused and with a rope, and thereafter they voluntarily
confessed before his father.
No.
Yes. PW1.
No, my lord, PW1, I'm reading the deposition of PW1, page 39, my lord. That the accused is my son, the deceased is my wife, being the mother of accused. About 1 year back on Tuesday, I had gone out to bring kerosene oil and returned around 9 a.m. After my return to the house of the accused also came back. Around 10 a.m., I went to the work of the accused and I returned about 12:30 p.m. The accused was sleeping in the house. I came and took my meal, and my wife was cleaning the rice. Again, I went for work around 2 p.m. My brother, Arakita Gowda, went and informed me that my son, the accused, was quarreling with my wife and was assaulting her. I, along with Chintamani Naik, Suresh Maji, Rajiv Maji, Khogeshwara Chandra, and Sadhu went to the house and found the dead body of my wife was lying inside the room, and found one tangia axe was lying, and the deceased was having bleeding injury. The accused was moving at a distance. Rajiv and Suresh Maji, Dhaneshwara Chandra, and Chintamani brought the accused, and being asked, the accused disclosed that he had committed the murder of the deceased. Thereafter, I reported the matter before the police. But in cross-examination, he has stated that I have not seen the accused assaulting the deceased. The accused never told me that he is influenced by different god Shiva. I have not heard accused saying that he is under influence of God, that he will preach and teach others. I cannot say the contents of the Exhibit 1, the PW1, as I cannot reading and writing. I had not told the scribe of Exhibit 1 that the accused is influenced by of God Shiva, and he wanted to preach and teach, and that for that he was quarreling with his mother. I cannot say if the accused is consuming liquor. The witness to whom I called from the road are not my relation. The person who went and called me are also not related to me. As I was not in the house at the time of occurrence, I cannot say if the accused was there in the house when the deceased was murdered. The scriber of the affair was not examined. And here the motive and the cause and the intention was not categorically disclosed by any of the witness. Rather, they are parroting witness saying statement, my lord. And the scriber of the affair was not examined, and the chain of circumstance has not been completely proved by the prosecution, my lord. And no blood stain was appearing in the wearing apparel of the accused, my lord. because there is a 16 injury as per medical. There is a 6 during the PW2 was a doctor who is conducted to the PM Malord. There is a 15 injury were caused by the sharp cutting weapon, and 1 injury is fracture. So no blood stain was found in the wearing apparel of the appellant, my lord. And the confessional statement was not voluntary. They are tied up him in a rope. There, and all the witnesses are stating like a parrot-like statement. So, and the appellant is custody, my lord, more than 12 years, 10 months.
Plus, payroll 1 happens to be his
Father.
And from his testimony, it is very much clear that the son, the accused has confessed before him that he has killed his own mother. And then by the time he arrived, he along with others, plus PW 4, 5, PW 8, as well PW 5, PW 6, all stated also that this accused person was moving just near the dead body of the deceased. And while he was asked, and he was caught by the villagers, and when he was asked, he said that I have killed my mother. And you'll also see the evidence of PW2, the doctor who has conducted autopsy. The number of injuries inflicted by the accused on the deceased. To what extent a son can be brutal towards his own mother? That is 15 inside wounds.
Yeah.
With fracture, everything.
And 1 fracture.
And here, even if extrajudicial confession is a weak piece of evidence sometimes, for here in the facts and circumstances of the present case, it is the evidence which substantiate the case altogether. And a father can be expected to depose against his own son. Yes. And question is, he has killed his own mother. And all the witnesses have supported PW1, all the witnesses, right from PW3 onwards, the number of witnesses who have been examined, all have stated. And the open of offense carries the blood of human origin, and so also the stained earth that was also carrying blood. And the sari of the deceased that was carrying human blood, no opinion has been given. But that is not a certain, that is an incriminating materials because the weapon of offense is already there. That was there, the weapon of offense was kept near the spot. And he was caught hold of by the villagers. It is evidence is substantial, no more evidence is required.
All right. Anything else, sir?
No matter.
All right. Orders reserved.
Supplemental list, item number 83.
So Zafarullah is just now here.
Which case? 83 is a jail criminal appeal, my lord, but we have not received any memo, my lord. No appeal memo is there with us. Paper book is prepared, my lord. We'll collect it. I'll collect it.
It says no further accommodation will be made. Who's this now sitting here?
Mr. Jaffrullah was here. 83. 83. Okay.
Pardon, my lord, Pastor, my lord, 83. My lord. I think, my lord, 80 my item.
83.
Yes, my lord. Pastor, my lord. Another court, my senior, my lord.
All right.
Item 84. Item number 84.
Pass over.
Item number 85.
Pass over.
Item 86.
Pass over.
Item number 87.
Taken up 2 weeks after, madam.
Why?
The appellant wants to engage the senior advocate so that she has taken the file and consult with the senior advocate, madam. Case of the year 2019, madam. Appeal inside the custody, madam. The appellant inside the custody. Appeal of the 2019, madam. 2 weeks after, madam, wants to.
Counsel to the appellant states that the appellant wants to engage some senior counsel. Listed on 22nd November.
Supplemental list item 88.
Well, in this case, I have not received paper book, but paper book ready.
Just give it to him right now.
But in this case, my lord, first bail application pending. I am ready for a disposal of first bail application.
We are ready for disposal appeal. How about that?
Appeal, my lord, I have not received paper
Just
book.
now, no more. This excuse goes away right now.
1 week time, my lord.
Paper book has been handed over to counsel for the
But a
appellant.
letter or passed, letter honorable court passed after receipt of the LCR, my bail application under session.
Now we are telling you, sir, now that you've got the paper book in your hand, we are ready to hear the appeal itself.
Put up 2 weeks after, my lord.
Counsel for the appellant now says that he would like to argue it after 2 weeks. List on 29th November.
Supplementary list item 89.
Let's item 89. Let's this pertains to that Puri matter. Let's Bagala Dharamshala. Let's
why is it so haphazard? Criminal appeal and then repetition, then again in between.
My lord, I am the petition. My lord, the London Council Mahanti had to take time. Last hearing to highly counter to file reply within 4 weeks, and the Honorable High Court has directed him to serve the copy of the reply to me to file it agenda. My lord, the Law Council for the state has taken time to time again and again, and not yet filed the reply to in my amendment in this case, my lord. My lord, on the order number 13, dated that 2nd May 2022.
If I may, Mr. D.K. Mohanty was conducting the matter. He has asked for because he has a bereavement in his family.
Oh, there is a bereavement, sir.
Therefore,
in Mr. D.K. Mohanty's family, there is a bereavement.
Therefore, I'm asking.
There is a bereavement in the family of. The court is informed there is a bereavement in the family of D.K. Mohanty AG. List on. Give me a.
And the opposite party number of my lord 6, 7, and 9 also not filed the counter in response to my amendment in this case. May kindly issue direction to them to the OP number 6, 7, and 9 to file the reply.
Meanwhile, opposite parties who have not filed their replies in writ petition civil 23988 of 2019 will do so within 8 weeks. Rejoined over for the next date. 30th November.
Respond to my amendment in this case, my lord.
whatever, sir. All,
Will you
all,
reply
all,
to Lordship in 25701? First,
All all right.
deeply obliged.
Item number 90.
May I please, Your Lordship? My Lordship, this is a CRLA matter of 2022 and the offence alleged under section 302, 304B, 498A, 34 and 4 of the Dowry Prohibition Act, my Lord. And my Lord, on city case number 142 of 2017, London Session Judge Tinkanad has pleased to sentence all the convict to suffer imprisonment for life and to pay a fine of rupees 5,000, and in default of payment of fine to suffer further imprisonment of 1 year. And of the under section 302 and 34 of IPC, the appellants are also sentenced to undergo imprisonment for 7 years for the offence 304B and 34 of IPC, and further sentenced to undergo imprisonment for 1 year and to pay fine of rupees 1,000, and in default of payment of fine to suffer further imprisonment for 3 years. For the offence under section 498 of IPC, the appellants again also sentenced to undergo imprisonment for 6 months and to pay fine of rupees 1,000, and in default of the payment of further imprisonment of 1 month for the offence under section 4 of Dowry Prohibition Act, and the substantive sentence shall run concurrently. My Lord, this is my bail application that is in IA number 431 of 2022 pending before your Lordship. And my Lord, I am pressing that my bail applications, that is for the appellant number 2 and 3. 2 is the brother-in-law and 3 is the old mother-in-law, old lady mother-in-law, my Lord.
How long have they been in custody?
Yeah, my Lord, during the trial, during the whole trial, the petition in the bail application, the petitioner number 1 and 2 is on bail during the trial. 2 and 3, my Lord. Total, my Lord, total 3. My
90 years old.
My Lord, petitioner number appellant number 3, Mataji Sahu, that she is in judicial custody for 3 months 1 day, and petitioner number 2, that is Prakash Sahu, he is in 6 months 19 days in judicial custody, and number 1, Kailash Sahu, he is in judicial custody for about 5 years 5 months and 20 days, my Lord.
For about 3 months.
My Lord.
Keeping in view these circumstances, the court directs that she be enlarged on bail during the pendency of the appeal, subject to the satisfaction of the trial court. The bail application is rejected at this stage as far as appellants 1 and 2 are concerned.
My Lord, so there is no family members left in the family, only 3 members in the family, and the petitioner number 2 is the only bread earning person, and the old mother of 90 years old, she has no way, helpless she is. So how can she survive? And she, in the judicial custody, she also slipped down and broke her leg in the bathroom. And my Lord,
No,
the
these
whole
others
case
are
is.
nothing.
Please.
You filed the bail application only for 2 of them.
My Lord.
Ah.
The brother-in-law, she wants bail for the brother-in-law.
Ah.
No.
For the but the allegation is omnibus, my Lord, in the sense that all of them have demanded dowry and tortured her, and they have burnt her to death, my Lord. Doctor, he said.
No, we are not inclined to release the Appellant number 2. All right. The main appeal is a list for final hearing on 12th December.
Pastor matter item 79.
Seventy-nine is 79.
79.
Your lordship posted it to Monday.
No, there's going to be a heavy vote. As it is, we have 90 matters. If you keep adjourning everything to Monday, that it'll add on to 90.
No, I think he has already done it. 79, my lord, time.
It's passed over.
It was passed over. Somebody was. Seven. 79, I think the appellant counsel has done his part. I had prayed for time for Monday. Item 79.
That was
The appellant counsel.
That was 80.
That was 80. This is Arzu Yasin versus State of Orissa. In that second one, that Barun asked notice without process fee to be served on Raman Kantapnayak. This Arzu Yasin, I think, is not on bail, no?
Item 79.
No, but is he on bail? I don't think so.
No, my lord. There are 3 connected appeals, my lord.
I know. In the second one, I think he's on bail. Can you find out the current whereabouts of the second appeal?
Yes, my lord.
None appears for the, you see in the first one, notice without process will be served upon J. Sahu, advocate, since he has not appeared, despite a password. In criminal appeal 574, you see the current whereabouts of the appellant, who was enlarged on bail by an order dated.
Your lordship is referring to order dated 16/7/2014.
17/7/2014 be ascertained by the IAC of the concerned police station and a report be submitted on the next date. Meanwhile, a complete set of the paper books be handed over to Secretary OHC LSC for him to assign it to a panel counsel of not less than 10 years experience, who will remain present on the next date. Then in criminal appeal 321/2011, none appears for the appellant. it is seen that he was enlarged on bail by an order dated 24th November 2016. His whereabouts be ascertained by the IIC of the concerned police station and the report be submitted at the next date. For similar order, copy of the paper book handed over. Plus accounts. We've given a date.
No.
7th December.
Pastor matter item 83.
Mr. Jaffrullah, somebody took time that he was in some other court, my lords.
Mr. Bismay Anand Pushti supposed to be
Yeah, his name is also shown.
shown. His associate time.
That's over. All that is over.
So he said.
None appears for the appellant. The appellant was released on bail. Notice be issued to the appellant to remain present on the next date. Notice be sent through the IIC of the concerned police station. Simultaneously, notice be issued to Mr. Pushti, who stated to have entered appearance on behalf. What Pushti is he?
B.A. Pushti. Bismay Anand Pushti.
B.A. Pushti, advocate, was entered appearance for the appellant. 7 December.
Supplementary list item 84.
The stay of fine, I think you can see the fine is stayed. That interim bail.
Sorry.
That stay of fine that you say the fine is stayed. All the remaining you say none appears for the appellant applicant dismissed for default. And then the main criminal appeal, say notice. You say none appears for the appellant. The registry is directed to supply a complete set of the papers. Secretary ONCLSC was in turn directed to assign the case to a lawyer in the panel, not less than 10 years experience. His name be shown in the list. You see list on 8th December.
Pastor matter item 85.
Nine 916 of 22 say none appears dismissed for non-prosecution. 1961 of 2017, what is that? Modify. That application was none appears. This was a default. Date. NBW. Yeah, so none appears.
My lord, in this case, 85, we have received an instruction, my lord, that this was in 2018, of course, my lord, will take fresh instruction. This, after being released on interim bail, he has absconded.
He has not come back after that.
Yes, and after that, I'll take instruction, my lord. This is 2018. Okay, noted.
Mr. Ashwini Kumar Das was permitted. So meanwhile, the IAC will furnish a report on the present whereabouts of the appellant. Notice without process fee issued to Mr. A.K. Das, advocate, to remain present at the next date. List on 13th December.
Item 86.
Pardon, my lord. In item 86, last Monday, I have received the paper book. So I pray for any date as your lordship fixed.
Fine, you say fine amount of state. That MC number 1678 is disposed of. At the request of counsel for the appellant, who needs time to prepare for arguments. List on 17th November.
Pardon, my lord.
17th November.
No, it's okay. No one in the focus.
Regarding item 80 plus. If that hasn't concluded, plus I'll file one written note of submission. 80 plus. Then on the wrong reason, my line of friend has taken time to Monday.
I was taking time on 79. I think he was doing 79.
No, he was 80. That was 80.
That was 80.
I'll file a short written note of submission. 80, item 80.
So we'll reserve orders.
With the lordship permission.
Reserve orders.
My lord.
You could tell the council.
Because he has argued. If a lordship will hear him.
Correct, I already heard it. So orders reserved in 80. All right.